I beg to mention, my lord, one introductory application for listing, my lord. The metro was last listed on 10/11/2025. Well, this is, IA has been filed, my lord, seeking condemnation of delay in filing the connected MSc appeal, my lord. But can it be on next Monday, my lord?
Okay.
Oblige.
May I please? I pray for listing of an FA on tomorrow, Lordship. There is urgency, Lordship.
What urgency?
The injunction has been granted. The due to which the ongoing construction has been stayed.
Okay. When have you filed?
Yesterday.
Okay.
May I please, Lordship? Lordship, I beg to mention item number 18.
Yes.
But my senior is not well, so kindly bring for the adjournment of the day.
Have you informed the other side?
Yes, yes, with a consent from other side.
It
Lord.
is tagged with item number 17.
18, my lord.
18 is tagged with item number 17. You have informed the other side.
Yes, Lordship.
What is your name?
J. Mosam.
Admin,
Kindly next step may given on date 19 or 20.
Ms. J. Musan, learned counsel for the appellant,
Respondent, Lordship.
learned counsel for the respondent, who prays for an adjournment on the ground of personal difficulty of the conducting counsel for the respondent. She submits that she has informed learned counsel for the appellant regarding her prayer for adjournment, who does not have any objection to the same. Hence, the prayer is allowed. Let this matter be listed on 26th of March,
Should give me going on 19 or 20.
20th of March.
May I please? Lordship, with the consent of the other side, I beg to mention item number 23.
20?
Three.
Yes.
Lordship, matter will be taken after Bihu vacation.
What is your name?
Mr. S. D. behalf of UB Sharma, appellant.
Third, Mr. S. Day, submitting on behalf of Mr. Yubishan, learned counsel for the appellant, who prays for an adjournment on the ground of personal difficulty. He submits that he has informed learned counsel for the respondent, who does not have any objection to his prayer. Hence, the prayer is allowed. Let this matter be listed on 30 April.
May I pray for listing an FA matter? 3/2026. Can it be listed on Friday or Monday?
When?
Friday or Monday?
Next Monday.
May I please, Lordship, I would like to take for mention for listing, my lord,
Listing what?
for MSc appeal. For
In orders column, next Monday.
next week.
Next Monday in orders column.
Okay, I have to mention one more, Lordship, for I.
Next Monday. No, 17 Martino.
Bail hearing. Item 4.
Yeah, please.
I know, can it be after sometimes, madam? He's on the way, Mr. H. Urgent.
Who is on the way?
Mr. H. Urgent. He's in the first floor. He's
At
coming
2, at 2,
to my lord.
Yeah, please, take case direct.
at 2.
Yeah, this one, item 1.
My lord, in this case, my lord, notice upon the respondent number 173. May I bring my lord, it may fix for hearing, my lord. LCR has,
This appeal has not yet been admitted.
my lord. That's why, my lord.
It has not yet been admitted. We'll admit it and fix it for hearing. Heard Mr. A. Manna, learned counsel for the appellant. Also heard Ms. R. D. Majumdar, learned counsel for respondent number 1. It appears that this appeal is not yet admitted. No, cut it. This appeal is admitted. Stop. Let this appeal be listed for hearing when after.
Next month, my lord, and date may be fixed, my lord. 2019 matter, my lord.
I don't have any issue, Lordship, any date.
23rd of April.
Item two,
Two.
My lord, here, my lord, there is, my lord, it is, the main appeal has come for admission, my lord. But nonetheless, my lord, there is also an IA for condonation. Where your lordship,
For condonation.
yes,
Yes.
and one interim order is also there.
Delay is not condoned till.
Then appeal, how appeal has been registered?
My lord. Now, the thing is, my lord, in delay, my lord, my friend is appearing.
Yes.
If he has no objection, that may be closed, my lord, and appeal may be heard, my lord.
Delay of 161 days. That's something.
And we have explained the delay, my lord.
You are.
And for the rest.
You are objecting.
I'm not objecting, just only one statement he has stated that he came to know about the appeal.
IA, my lord, 2382. The malicious prosecution, my lord, judgment. I have explained the, my lord, delay, my lord, what happened, my lord. That he was at that time, my lord, additional chief engineer, my lord, of the department concerned. Now, in that capacity, he lodged an FIR, my lord, against the respondent, my lord. As he was an RTI activist, my lord, he entered the so and so, my lord. Allegation are there. Now, against that, my lord, he filed, my lord, he got an acquittal, my lord, he filed a suit, my lord, money suit, claiming some compensation of 30 lakhs, my lord. And that delay I have explained, my lord, that I have filed written statement also, my lord, in that case.
No, no. What is the reason for delay?
Delay, your lordship will find, my lord. I have explained paragraph 4 onwards, my lord. Paragraph 4, page 5, my lord. That the applicant stated in the aforesaid money suit, he filed his written statement stating on the instruction of the authorities of paragraph 4, my lord, page 5, my lord. I have filed written statement, my lord. Thereafter, my lord, I did not appear, could not appear because of I suffered from TB, my lord, tuberculosis disease. So I could not know the, my lord, the judgment was delivered, my lord. Now,
So
when
you are at fault.
I'm a department engineer, my lord. He filed a money suit, my lord, adding all the department concerned. I am defendant one, my lord, in that suit, my lord. So I filed written statement.
Otherwise, Mr. Faridi, you are not opposing.
Not opposing, but only one statement that he came to know that in one paragraph he has stated he came to know in the last week of June 2025. But
Yes.
he have filed a written statement in the main suit.
No, written statement was filed at that point of time. After that suit proceeded against me, my lord, and I was not facing the trial. And only on the executive, because I retired.
Heard Mr.
I
B.
retired from service, my lord.
Learned counsel for the applicant. Also heard Mr. S. F. Faridi, learned counsel for the respondent. This application under Section 5 of the Limitation Act 1963 has been filed by the applicant praying for condonation of delay of 172 days in filing the connected regular first appeal, whereby the judgment dated 22/10/2024 and decree dated 30/10/2024 passed by the Court of Learned Civil Judge Senior Division, Karbi Anglong, Defoe in money suit number 2/2022 has been impugned. Learned counsel for the applicant has submitted that the applicant has explained the reasons for delay in approaching the court in filing the connected appeal in paragraph number 4, 4 and 5 of the instant interlocutory application. Stop. Learned counsel for the respondent, Mr. F. Faridi, has not objected to the prayer for condonation of delay. I have gone through the materials on record, as well as considered the submissions made by learned counsel for both sides. Considering the reasons stated in paragraph number 4 and 5 of this interlocutory application as sufficient cause which prevented the applicant in approaching the court in filing the connected appeal within the prescribed period of limitation, comma, the delay of 172 days is hereby condoned and this interlocutory application is allowed. It appears that the registry has already registered the connected regular first appeal as RFA number 59 of 2025. This interlocutory application is accordingly disposed of.
I was not provided with the memo. Appeal.
My lord.
No, now we'll pass orders in appeal.
Appeal RFA 15.
RFA, heard Mr. B. Barwa, learned counsel for the applicant, appellant. Also heard Mr. F. Faridi, learned counsel for the respondent. This appeal under section 96 of the Code of Civil Procedure has been filed by the appellant impugning the judgment and decree dated 22/10/2024 and 30/10/2024 respectively by the Court of Learned Civil Judge Senior Division, Karbi Anglong in money suit number 2/2022. This appeal is admitted. Stop. Since Mr. F. Faridi has already appeared for the respondent, no formal notice need to be issued to the respondent. However, the appellant is directed to furnish a copy of memo of appeal along with the annexures to the learned counsel for the respondent. The registry shall take steps for requisitioning the records of money suit number 2/2022 from the trial court. Release this matter after receipt of the trial court records on 8th of April.
But see, my name may be reflected in the cause list.
The name of Mr. F. Faridi may be reflected in the cause.
Take up the IA also for impugn judgment stay of the IA 3522.
I was not provided with a copy of.
I will give, but he is appearing now.
We'll issue notice in I, you provide in copy.
My lord, your lordship will protect it because they have started the execution, my lord. That's why we have to hurriedly come, my lord. And there was an interim order in the condonation. The court has, so your lordship may, till the retirement date, your lordship may consider, my lord. I have sufficient grounds, my lord. That is the thing, my lord. Your lordship will hear it on merit on the appeal. Because they execute.
What was the decree?
Decree for my lord, claiming compensation, my lord.
How much
30
compensation?
lakhs, my lord. From a retired engineer claiming malicious prosecution. I was
30 lakhs was decreed.
my lord. Highly, my lord, my lord.
You have started execution proceeding.
Yeah, execution is.
I have a copy, my lord. That is the thing, my lord, that I am a retired person, my lord.
This interlocutory application heard so and so. heard Mr. B. Burwa and F. Faridi. This interlocutory application has been filed by the applicant under Order 41 Rule 5 of the Code of Civil Procedure in connection with the connected RFA number 59/2025. Praying for stay of execution of the decree dated 30/10/2024, passed in money suit number 2/2022. Learned counsel for the applicant has submitted that the respondent has already initiated a money execution case, that is money execution case number 1/2025 before the executing court for execution of the impugned decree. Stop. On the other hand, Mr. F. Faridi, learned counsel for the, you will be filing any objection?
I'll be filing objection.
Learned counsel for the respondent submits that he has not been furnished with the copy of the interlocutory application, and the respondent intends to file a written objection against the prayer made by the petitioner. The applicant shall furnish a copy of the interlocutory application along with annexures to the learned counsel for the respondent during the course of the day. Learned counsel, the respondent may file a written objection on the next date fixed. However, as the execution proceeding has already been initiated, hence till the next date, the proceedings of money execution case number 1/2025 pending before the Court of Learned Civil Justice Senior Division Karbi Anglong shall remain stayed.
It has been transferred to
Long shall remain stayed. List accordingly. Eight.
I'm very sorry, my lord, I was on the way.
Now what is,
Yeah, I don't know if possible in the first term, yes.
yes, Mr. Goswami, should we take it now?
Not. I'm very sorry, my lord. It's a bail application, my lord. And in fact, Lordship had earlier gone through this case, my lord, on more than 2 occasions, my lord. And Lordship was pleased to reject.
His diary is there.
Case is also always same is that a victim is implicated and other witnesses also implicate the petitioner.
So this is not a case for,
Only that ground we have taken, my lord, that issuance of 35(3) notice, my lord. Now it has been held, my, it is a rule, my lord, because possibly that has to be followed, my lord. Here, my lord, the punishment, maximum punishment is, my lord, 7 years, my lord. And my lord, that notice, not yet possibly it will be reviewed from diary also possibly have, it has not been served, my lord, or issued, not a single time, my lord. Because here, my lord, those sections, my lord, these grounds possibly not taken, my lord, earlier. Because case has been registered under, my lord, 75(2) of BNF, my lord, which is punishment is 3 years, my lord, extend to 3 years. And 78(2), my lord, that is also extend to 3 years, my lord. And so far, my lord, the special act is concerned, my lord, here, my lord, section 10, that is not less than 5 years, but which may extend to 7 years. That is the maximum period, my lord. And my lord, some mitigating circumstances, because my lord, that person, my lord, on the verge of retirement around 58 years, my lord. And the the investigation started, my lord, on 26/12/2024, my lord. The FIR, my lord. That we have annexed page 21, my lord.
Where is the earlier rejection? on that?
Earlier, my lord, last, lordship may kindly see the last, my lord. That lordship find, my lord, page 83, my lord. That was
What is the progress of investigation?
It's a Welton house was searched, but
Then why are you not filing the
That's-
charge sheet?
What?
If investigation is over, what for the investigating
Last-
officer is waiting?
the last note of the ILOT 28 to 26.
What is the note?
Notice his house was searched and the victims, accused son and wife's statement recorded that he was not present at the house when house was searched. That is the last note of the IO. And statement of the wife and the son of the accused.
No, that,
No, whether investigation is, what is this?
my lord, but recent, my lord, judgment of the Honorable Apex Court, my lord, that 35 note, free notice is the rule, my lord.
Which para?
Here, lord should find, my lord, the conclusion, my lord, page 32, and the law laid down, page 33, my lord. Lord should have see para 33, my lord.
Yes.
My lord would find that on the basis of the interpretation given by my lord.
No, which portion you are
Rule.
relying?
My lord, I am relying on, because my lord, arrest also not mandatory, that para A, my lord.
So you are not arrested till now.
No, that is true, my lord. Now, my lord, that D, my lord, is the rule, my lord.
Where they will furnish the notice, you are not available.
If the notice was served at home, my lord, because they are that to any member of the family, they can serve, my lord. As per that section, my lord, 67, because they did not send, my lord. Earlier, it was the male member was there. There has to be a male member, CRPS.
So if notice is not served,
Yes, my lord.
then what is the consequences?
Consequence, my lord, he may be arrested without serving notice. Then we have to come under 430, my lord, the
Then
regular.
you will get bail.
But my lord, kindly see, my lord, the latest, then it is a rule, my lord. So when the investigating agency for last more than 1 year, they're not issuing it, my lord. That itself is a violation of the order passed by the Honorable Apex Court. My lord. Now, even knowing it that it has not been served, my lord, if we had not placed that thing, my lord, if we had not argued on that line, they would have been a different, my lord.
BNS is the option. Yes.
No, so let's 60. '66 of BNSS, my lord.
What is 35.3?
But actually that, my lord, earlier 41A, my lord.
No, read 35.3.
My lord. The police officer shall, in all cases where the arrest of a person is not required under subsection 1, issue a notice directing the person against whom a reasonable complaint has been made, or credible information has been received, or a reasonable suspicion exists that he has committed cognizable offense, to appear before him or at such other place as may be specified in the notice. So notice, my lord, earlier, because, my lord, the law was, my lord, that, my lord, even after issuance of 35.3, my lord, a person could have been arrested, my lord. Now, because of this judgment, my lord, it's.
No. The question before
My lord.
in this case is different. You are not arrested.
Understood, my lord.
If the question is if 35(3) is not issued,
My lord.
whether you are entitled to get anticipatory bail
That is true, my lord, but.
because you are yet to be arrested.
It is true, my lord, but since, my lord, it is a rule, and for the last more than 1 year, my lord, investigation is going on, and it is apparent from the case diary possibly that till
We
yet.
will issue direction to issue the 35(3) notice to you.
Yes, my lord. That would
One
suffice.
notice was served also. I have given the
35(3).
CD of his wife is.
What is your
Next acknowledgement, his wife's signature is there also.
wife's name?
Wife's name, my lord, is there. My lord, Nilakshi Devi.
So it has been served. This point goes.
My lord, that was, you are not instructed on that count. My lord. Can I see that date, my lord?
No, this is part of case diary.
Understood, my lord. But if it was served, my lord, whether,
Then you don't have a case.
can I take that instruction, my lord, because we are not aware, my lord, regarding that, my lord.
No, but it is now you have only option either to withdraw or I'll dismiss it.
Then, my lord, can I make an alternate prayer, my lord, that this person is, my lord, running from.
No.
No, alternate, my lord, that Lord may protect him for some days, my lord, he'll surrender, my lord.
No. Use
I'll rely on this, my lord, one judgment. Lordship discretion, lordship may or may not, my lord, but I'll just, even in a case where lordship thinks that, my lord, that anticipatory bail is not, cannot be granted, then also possibly lordship can grant him considering the mitigating circumstances, my lord. Yeah, I'm relying on that para 23, lordship, kindly look at once, my lord.
para
23, my lord.
yes.
Here, my lord, would kindly see, my lord. Even when the court, that third line, even when the court is not inclined to grant anticipatory bail to an accused, there may be circumstances where the High Court is of the opinion that it is necessary to protect the person apprehending arrest for some time due to exceptional circumstances until they surrender before the trial court. For example, the applicant may plead plead protection for some time as he or she is the primary caregiver or breadwinner of her family and needs to make arrangements for them. In such extraordinary circumstances, when a strict case of a grant of anticipatory bail is not made out, and rather the investigating authority has made out a case for custodial investigation, it cannot be stated the High Court has no power to ensure justice. And even, my lord, if I don't appear, my lord, that one line lordship would, my lord, even after, my lord, that one observation is there in that earlier judgment, my lord, that despite, my lord, non-appearance, my lord, a person may not be arrested, or it is not that, my lord, he has to be arrested, my lord.
No, it is.
Not a matter of course, my lord, that one observation in this earlier judgment, my lord. But even if 35(3) notice was given, my lord, thereafter person doesn't appear, my lord. Earlier it was that he could have been arrested, but this judgment makes it clear that it is not as a matter of course, my lord. Definitely the discretion is there to the higher, my lord. Can I ask that date, my lord, that notice date? Date of 35(3) notice, my lord. Date, my lord.
No, what is your prayer? You want copy of 35(3) notice?
I can just have a look, my lord. Or Lordship thinks day after tomorrow, I'll take instruction, my lord.
Okay, you take instruction. Heard Mr. A. Chaudhary, learned counsel for the applicant petitioner. Also heard Mr. B. D.P. Goswami, learned additional public prosecutor. This is for the third time the petitioner.
Fourth time, my lord, I'm sorry.
This is for the fourth time the petitioner has approached this court for seeking anticipatory bail in connection with Morigaon PS case number 352/2024. Stop. This time the main ground for seeking bail by the petitioner is that he has not been served with any notice under section 35 within bracket 3 of the BNSS 2023. Stop. However, learned additional public prosecutor has produced the case diary and which contains a copy of notice under section 35(3), which has been served on the wife of the petitioner. It also appears that wife of the petitioner has ascribed her signatures on the said notice. Stop. Learned counsel for the petitioner submits that he was not aware about this aspect and seeks 1 day time to take necessary instruction before he makes his further submission. Prayer is allowed. Let this matter be listed again on 12th of March.
Much obliged.
Noted.
Item 3.
Yes.
My lord, this is an appeal filed by the insurance company. Lordship. This case, the driver did not have a valid driving license. Main town of the appeal is that the driver did not have a valid, he was holding a fake driving license.
Driver did not have a
Valid
valid.
driving license, he was holding a fake driving license. My learned friend has appeared for the respondent number 1 to 3. Lordship.
Heard Mr. K.K. Bhatto. Learned.
My lord, I have submission, my lord.
Yes.
That, my lord, they have filed, they have stated that the driver had no valid license, but they have not taken any defense witness, my lord. They have not adduced any evidence. Even in the argument also, they have not mentioned this. And
On what basis you are saying?
Lordship, after passing the judgment, we filed a review petition. Lordship, a review petition. In the review petition, it was Lordship. Defense was taken. Lordship, subsequently some development was there, and we produced the driving license verification report. But that was not considered. That was dismissed. Lordship, appeal may be admitted. Lordship, call for the record. Lordship.
My lord, owner and driver have submitted written reply, my lord. But they have stated in the argument that
No, on why your review was dismissed?
Lordship, since that defense was not taken prior to judgment. Lordship.
they have got the investigation report in 2021, my lord.
Lordship.
And I have adduced evidence of the claimant in the year 22, and they have crossed in 23. And judgment was,
We are not giving any stay on execution.
no, they have not said. They have not stated anything about this, my lord.
Lordship,
And they have got time.
Is there any,
If they have got, my lord.
is there any interlocutory application filed in this case?
Yes.
Uh,
yes, sir.
We are not granting any stay. We are admitting the appeal.
My lord, award may be allowed to the claimants, my lord.
No, you can
Who have
go.
interest, full award may be allowed, but after that, they will continue with the owner, my lord. My lord, claimants have no,
Lordship, we
they
will
have
deposit-
no rule in this.
deposit 50% awarded amount, they may be allowed to be withdrawn. Lordship.
I want, my lord, my prayer is to allow full amount, my lord, with interest, because the from 2010, no? From 2020.
Heard Mr. K.K. Bhatto, learned counsel for the appellant. Also heard Ms. D.D. Roy, learned counsel for respondent number 1. This appeal under section 173 of Motor Vehicles Act 1988 has been preferred by the National Insurance Company Limited impugning the judgment and award dated 9/5/2024 passed by the Motor Accident Claims Tribunal number 3, Kamrup Metro, in MAC case number 2013 of 2018, whereby the appellant was directed to pay a compensation amount of rupees 14,17,000 with interest at the rate of 9% per annum till realization. Stop. Though learned counsel for the respondent has objected to the admission of this appeal on the ground that the insurance company, during the inquiry before the Motor Accident Claims Tribunal, did not take the plea which they are raising in this appeal. However, after considering the grounds mentioned in the memo of appeal, this appeal is admitted. Let the notice be issued to the respondent. Since Ms. D.D. Roy has appeared for respondent number 1, who are 2 and 3?
Yes, 120.
You are for 2 and 3 also?
2 and 3.
1, 2 and 3. No formal notice need to be issued to the
Yes.
said respondent. As regards respondent number 4 and 5, the appellant shall take steps for issuance of notice by speed post as well as by usual mode within 7 days from the date of this order, returnable on 6th of April. Let the records of MAC case number 2013/2018 be called for from the concerned tribunal registry to take steps for requisitioning the records. List accordingly. I'm allowing you take 50% now.
My lord, full amount may be paid. What is the rule of the claimant here? She is suffering, my lord. Her daughter is also suffering chronic lung disease. They are suffering. So there is no rule of the claimants regarding this, my lord. So their amount may be released. And thereafter the case may be continued against the owner driver.
Heard Mr. K.K. Bhatto, learned counsel for the applicant. Also heard Miss D.D. Roy, learned counsel for respondent number 1, 2, and 3/claimant. This interlocutory application has been filed by the applicant insurance company in connection with the connected MAC appeal number 106/2026, praying for stay of execution of the judgment and award dated 9/5/2024, passed in MAC case number 2013/2018 by the Motor Accident Claims Tribunal number 3, Kamrup Metro, whereby a compensation amount of rupees 14,17,000 along with an interest at the rate of 9% per annum was directed to be paid to the claimant's respondent. Stop. Learned counsel for the applicant has submitted that the applicant has impugned the aforesaid judgment and award in the connected MAC appeal, and which has already been admitted. He further submits that the insurance company is ready to pay ready to deposit 50% of the awarded amount before the registry of this court as a condition for grant of stay of execution of the impugned judgment and award. Stop. Though learned counsel for the claimant / respondent number 1, 2, and 3 have objected to the said prayer. However, considering the fact that the connected appeal has already been admitted, as well as considering the grounds stated by the grounds taken by the applicant in the connected memo of appeal, this court is inclined to allow this interlocutory application. Since the applicant is ready to deposit 50% of the awarded amount, notice to other respondents, that is respondent number 4 and 5, is waived. Stop. This interlocutory application is accordingly allowed. No,
Right.
not accordingly allowed. A line to cut off. The insurance company is directed to, no, sorry. The impugned judgment and award dated, the execution of impugned judgment and award dated 9/5/2024 passed in MSC case number 2013/2018 by Motor Accident Claims Tribunal number 3, Kamrup Metro, shall remain stayed till the pendency of the connected MAC appeal number 106/2026, subject to the depositing of 50% of the awarded amount by the insurance company before the registry of this court within a period of 6 weeks from the date of this order.
Interest then, 50% with interest, my lord. They are suffering from, my lord.
6 weeks from the date of this order. Stop. If the insurance company deposit the same said amount within the time prescribed by this court, same shall be dispersed by the registry to the
This may be deposited in MSC 3, my lord, because the party is from Shivsagar. They have to come twice, my lord, once
Okay.
for here and again for.
that
court
can be
number-
done. That can be
Court number 3, my lord.
last.
In the prescribed period of time.
No, before that. The no, insurance company before the no, but the case has been filed in Kamrup.
Yes, my lord. So if amount is deposited in MSC 3, my lord, they come for only once. But here file, then they have to come here once, then again for verification, they have to come there, my lord, in 3. After verification, only High Court will disperse the amount, my lord. So if the amount is deposited in court number 3, one day they will
Instead of registry likhebo, shall deposit the 50% of the awarded amount.
with interest, my lord. My prayer is that.
Motor Accident Claims Tribunal number 3, Kamrup Metro, within 6 weeks. If the insurance company deposit the said amount in pursuant to this court's order, the Motor Accident Claims Tribunal number 3, Kamrup Metro, shall disburse the same to the claimants after proper verification. This interlocutory application is accordingly disposed of.
Item 27 from supplementary list.
Decision statutory appeal, lordship. In this case, lordship, the vehicle insured by the present appellant was driven by the claimant victim, lordship. And as per evidence on record, accident took place due to rash and negligent driving of another vehicle. but the learned tribunal below Lordship held the vehicle insured by the present appellant liable. We are the insurer of the non-offending vehicle. So non-offending vehicle cannot be held liable, Lordship. Evidence is there, other vehicle was responsible for the accident, Lordship. It is their evidence, Lordship. But that is the wrong, Lordship. We have tried this.
No, why this appeal is coming up so late?
Lordship, there was, this case, Lordship, has got dismissed for recall. Lordship, our name was not shown in this case. Lordship.
Thereafter it was restored.
Yes, Lordship, only on.
But it is yet to be admitted.
Yes, Lordship, this is for admission, Lordship.
Heard Mr. A.J. Soikia, learned counsel for the appellant. This appeal under section 173 of Motor Vehicles Act 1988 has been, till now, no execution case has been filed.
Execution has been filed, Lordship, 2098 pending before your Lordship. Only last week, Lordship gave us some time, Lordship. It is still pending. Before his Lordship case is filed, case is pending, 2098.
Execution case is pending before which court?
Execution, Bakizai officer, Lordship.
Then
Lordship had given us stay, Lordship, till today. 2098 Lordship is there.
under section 173 of Motor Vehicles Act, impugning the judgment and award dated 30/11/2013 passed by the Motor Accident Claims Tribunal number 2, Kamrup Metro, in MAC case number 1612/2006. I have gone through the grounds taken by the appellant in the memo of appeal. This appeal is admitted. Issue notice to the respondents. The appellant shall take steps for issuance of notice upon the respondents by speed post as well as by usual mode within 7 days from the date of this order, returnable on 7th of April. Let the records of MAC case number 1612/2006 be called for from the concerned tribunal. List accordingly on 7th of April.
Our IA for stay is there, Lordship.
You pay 50%.
Yes, Lordship, we are going to deposit 50%. Not to be released, Lordship. 233/7/19. IS.
No, what is this 2098?
That 2098 Lordship for staying the Bakizai proceedings, but later on Lordship warrant of arrest was also issued. So my prayer is that Lordship in IS Bill 2337/19 we are going to deposit Lordship 50% and the full stay against warrant of arrest may be issued from this honorable court, Lordship, in 2098.
Two zero 2337.
2337/19.
This has been disposed of in 23 itself.
Lordship, by order dated, Lordship, on last order, Lordship, in MC 91. MC 91, Lordship, had first order to restore this IA also along with the main appeal. Paragraph 9, Lordship.
I've heard Mr. A.J. Soikia, learned counsel for the in 2337. This is not listed. List hoise niki?
Order was there, Lordship, for restoration.
But this has to be restored. Because otherwise it will be shown as disposed of in the website. Registry has not followed up
Yes,
the order. We'll direct the registry to comply with the order passed in and again list it because this 2337 has not been listed today.
Yes, Lord.
Is it listed?
Order was there, but it is not. File is there, Lordship. Record is there.
Main MSC তে লিখো, main MSC continue করো. It appears that by order dated 27/2/2026 passed in MC number 91/2023, the registry was directed to restore the IA Civil number 2337/2019 and list the same along with this instant MAC appeal. However, same has not been done. Registry is directed to do so. Registry is directed to comply with the order dated 27/2/2026 passed in MC case number 91/2023 and after restoring the IA Civil number 2337/2019 list the same along with this MAC appeal on Monday. Monday will pass order.
Monday, Lordship.
On 16/3/2024, 2026.
Lordship, till then, Lordship, arrest warrant maybe.
In 2098 লিখিব IA 2098. Heard Mr. AJ Saikia. It appears that the connected MAC appeal number 43/2023 has been admitted. It also appears that the IA number both of you. IA number 2337/2019, which was directed to be restored, has been directed to be listed on 16th of March 2023. Till that date, the warrant of arrest issued by Bakijay certificate officer shall remain stayed. List accordingly. Mhm. 16/3.
Item 28.
Lordship, the conducting council is out of station. So Lordship may be pleased to pass over the matter for the day. If it may be listed tomorrow, yeah.
This is for final disposal. What is the urgency? What is the matter?
Your Honor, during the pendency of the title appeal, they have encroached upon the suit land and they have started construction. And as per the Honorable Court,
Which order you are impugning in this case?
17 to
Lordship is an injunction matter. They have filed one title appeal. During the pendency of the title appeal, they have filed one miss case for granting injunction. And the learned first appellate court did not grant injunction.
Lordship.
Against that, they have approached this
Yes,
court.
Yes, Lordship.
Okay.
Lordship, it's a decretal property, Lordship. The suit was handed over to us. And we have right title in interest over the property, Lordship.
But Your Honor, you were not made party to the suit when was decreed. So that's why we prefer an application before the executing court, which was dismissed, and they later on.
You filed an application under Order 21, Rule 99.
Yes.
That was also dismissed.
Yes,
It was
dismissed,
also
Lordship.
dismissed, and against which we have preferred an appeal.
This appeal.
Not
No, Lordship, in
dismissed,
the district
appeal
court.
is pending before the honorable district court.
This is against dismissal of
Interim.
your prayer for grant of injunction.
Yes, Lordship.
Yes,
Okay. By the first appellate court.
yes,
What is your name?
R. Chaudhary.
Heard Mr. R. Chaudhary, learned counsel for the appellant. Also heard Mr.
A Singh, Lordship.
A. Singh, learned counsel for the respondent, who prays for an adjournment on the ground of personal difficulty of the conducting counsel for the respondent. The prayer is allowed. When?
Your Honor, it may be taken up on 13th March,
13th March is okay.
Yes, Lordship. We have no issue.
13th March.
Obliged, Lordship.
Order, item 5.
May please Lordships. My lord, originally, my lord, I am the, my lord, claimant in MSC case, my lord. And my lord, the learned trial court has awarded, my lord, in my favor, my lord. And thereafter, my lord, insurance company, in this case, my lord, two insurance companies, my lord. And out of the two insurance company, my lord, the New India Assurance Company has filed a petition, filed, my lord, appeal, my lord. And at the time of staying the, my lord, operation of the judgment, my lord, this honorable court has passed a order to deposit the 50% of the awarded amount. And accordingly, my lord, the opposite party, my lord, the appellant has deposited, my lord, 91,190 rupees on, my lord, 22/02/2019, my lord. 22nd of February 2019, they have deposited, my lord. 91,190 only, my lord. And my lord, I have filed this petition for releasing the same, my lord. Yes, because, my lord, since, my lord, the claimant petition has been suffering, my lord, since long, my lord. 2012 matter, my lord.
By order dated 12/3/2022 to 2020, we were asked to give a copy, but copy has not been received by us till now.
Copy of this.
Yes, ma'am.
I will serve, my lord.
But so we do not know what the contents of this petition, 520. And our occupancy also
I will
there,
supply,
Lord.
my lord, today.
Our vehicle is not offending, Lordship. That is, we want to take stand.
No, you furnish the copies.
Today itself, my lord.
Then we will have to take it up after that.
My lord, then, day after tomorrow, my lord.
Next Monday, Lordship.
Next.
Heard Mr. S. Ahmed, learned counsel for the applicant. Also heard Mr. A.J. Saikya, learned counsel for respondent number.
This one, yeah, this one, my lord.
This one, number one.
This one, number one, Lord. This one.
You are, Mr. Saikya, you are for
New India, Lordship. New India Assurance Company Limited.
respondent number. One. And you have not made the other respondent as party.
But as because, my lord, the New India only.
Oh,
my
who
lord,
submits that? Who submits that in spite of the directions given to the council by this court by its order dated 12/3/2020, he has not been furnished with the copy of the interlocutory application. Stop on this, Mr. Ahmed, the learned counsel for the applicant, submits that he shall furnish the copy of the interlocutory application during the course of the day. Stop. Considering the above facts, let this matter be listed
After tomorrow, my lord. Day after tomorrow.
Monday, 16th of March, Monday.
My lord. Much obliged.
Item 6 and 7.
By the last order, it was supposed to produce a peon book, which they have said that it is available with them.
No, State was supposed to do what?
Produce a peon book, original peon book, which on the last occasion they have submitted it, it is with them.
By which order?
At the last order, 26 to it. 26.
26?
That's why I get in 1014. I 1014.
26, no, 19/1/2026.
19-1.
19/1.
19.
19/1/2026. Lordship.
In 101.
1014.
One zero one four is for what?
Condonation of delay, Lordship.
It is not yet.
Not yet condoned. Lordship.
condoned.
In fact, they have not filed any affidavit. State has not filed any affidavit.
I'm for the private respondents. Lordship.
Why peon book was asked to?
Because they have annexed a document wherein they have annexed a peon book. I don't know how they have got it.
Yes, Lordship, we have filed one affidavit in opposition where we have annexed the relevant portion of the peon book, Lordship. Where
To show what?
Pardon?
To show what?
It shows that they have received the information about the pendency of the original execution case, Lordship, reference case, Lordship, in 2010 itself. Now they are saying that they have done, they accrued the knowledge in 2022. That peon book is.
Where is the peon book? Mr. Gogoi.
Lordship, I have taken the step, today I have received an instruction from the office of the deputy commissioner, Lordship.
What instruction?
They have instructed that yet to be tested the original peon book as because of it is so old. That's why they requested another 2 weeks time for producing the peon book, Lordship. That's why I may be requesting in this court to Lordship, I may be allowed to another 2 weeks time to produce the peon book, Lordship.
Okay.
So in fact, they have not filed any affidavit, Lordship.
No need to file affidavit, Lordship.
And they have
Private respondent have filed a affidavit in opposition, Lordship.
While producing the peon book, you may also file an affidavit.
Lots.
By way of affidavit, you may produce that peon book.
Lots.
Heard Mr.
M. Gogoi, Lordship.
M. Gogoi, learned counsel for the applicant. Also heard Mr. N. Kolita, learned counsel for respondent number 1, as well as Mr. T. R. Gogoi,
Lots.
learned government counsel appearing for respondent number 2. While considering this application filed by the applicant for condoning the delay of 4,792 days in preferring the connected appeal, it was pointed out by learned counsel for the respondent number 1 that the applicant were aware about the pendency of the reference case in the year 2010 itself, and to substantiate the said submission. A, an extract copy of peon book was annexed as annexure B by the said respondent to his objection. Stop. It also appears that by order dated 19/1/2026, Learned Government Council was requested to produce the original peon book before this court. However, Learned Government Advocate Mr. Gogoi has produced a communication dated 9/3/2026 written to him by the Additional Deputy Commissioner Kamrup Metro, whereby 1 week's time was sought for to trace out the aforesaid peon book. Stop. Learned Government Council has accordingly prayed for 2 weeks' time for production of the aforesaid peon book and also for filing the same by way of an affidavit. The prayer is allowed. Let this matter be listed on after 2 weeks. 31/3.
Can it be on 20?
When?
27.
27/3. Okay.
Organized.
Item K.
Please, Your Lordship, am I audible?
May I please, Your Lordship? Your Lordship, in I Civil 2202 of 2025, my Lord, I'm appearing behalf of the opposite party number 3, my Lord. And the reply to that effect is ready, my Lord, and is to be filed, my Lord. Kindly, I'm just seeking 3 days time to file the reply. And
3 days time to file.
the reply by opposite party number 3, my Lord.
Your Lord's opposite part number 2, I guess. Your Lord's 3 is Indian Bank, Your Lord's, I think.
My Lord, what had happened?
By 2 or 3?
Your Lordship, 3 is Indian Bank.
You are appearing for 3.
My Lord. No, actually, my Lord, in the RFA, I am respondent number 2. In IA, my Lord, I am opposite party number 3.
IA 2202.
Yes, in IA 2202, my Lord.
Your Lord's, in the affidavit
I
supplied by
am
him also, he is mentioned opposite party number 2 only.
Yes, my Lord. So there is a mistake while I filing the affidavit that was ready. It was pointed out to me that it is opposite party number 3 and respond number 2. So
Yes,
correction has to be made.
in the IA, the opposite party number 3 is Miss Rita Mandal.
Yes, my Lord. So there is a small mistake while I'm filing the reply, my Lord. I'll correct and I'll file tomorrow, my Lord.
Your Lord's, may I submit, Your Lord's? I'm opposing this prayer because, Your Lord's, he had sought permission to file this affidavit on 4th of February. Your Lord's, may I just brief about the facts of this matter, Your Lord's, in 2 minutes?
No. If they are seeking only 1 day time,
Yes,
by tomorrow they will be filing. Let them file.
Yes, ma'am.
Your Lord's,
We'll
please.
take up the matter day after tomorrow.
Please, Your Lord's, please, Your Lord's. Highly request.
Your Lordship, maybe day after.
Heard Mr. in IA 2202. Heard Mr. N. Goenka, Learned Counsel for the applicant. Also heard Mr. B. Chakravarti, Learned Counsel for
Union of India.
Learned Central Government Council, appearing for opposite party number 1. Also heard Mr. Union Bank is
Indian Bank, Your Lordship.
what is your name?
M. Sharma.
Heard Mr. M. Sharma, appearing for respondent number 3, opposite party number
4 in I, Your Lord's.
4 in the IA. Also, Mr. S. Sancheti, appearing for respondent opposite party number 2, who submits that the affidavit, the written objection to be filed by the opposite party number 3 is ready. However, it is yet to be filed, and he seeks 1 day's time for filing the same. Considering the prayer, considering the submission, the prayer is allowed. The opposite party number 3 is granted a day's time for filing the written objection. Let this matter be listed again day after tomorrow, that is on 12th of March.
Your Lordship, no further time may be allowed
No, no,
because
no,
it's a
we'll do it.
liquidation process.
We will do it, my lord. It's ready.
12th of March.
Ready, I'll do it.
This will be the last chance.
Okay, Your Lordship.
Liquidation is in the advanced stage. Everything has been finished. Only the subject matter of the title suit is pending.
No, on that day, we will try to dispose of the
Yes,
aisle.
yes.
Highly obliged.
Highly obliged, my lord.
In mind. Item number 9.
None has appeared for the appellant on call. Let this matter be listed
20.
on 20th of March.
Item 10.
My lord,
This is a delay combination application.
they file objection. And dispute between two brothers and sisters. And when the matter was running on, then talk of compromise was going on. Yeah, I also filed a title suit, and that case also pending. Ultimately, lastly, she refused to compromise the matter. So that is why I am not filing the appeal in due time. Actually, this will be
How much delay?
220 days.
200. Where have you explained?
Let's look at this paragraph from paragraph 4. 4, 5, 6. He filed objection regarding that
Whose property was bequeathed?
our
Your father's or
other
mother?
property. There's a
It,
property,
it was given to your sister.
it was ultimately taken to my mother. Then my mother given to my sisters as a will.
And you have objection to that.
Yes, I have to do that. And in this regard, title suit is also pending. I file a title suit also because ultimately, subsequently, my sisters hold land to other persons, third party. So I file a title suit that is pending. So last occasions we are decided to settle all the matter
Land has already been sold to some third person.
with third persons. So that is why matter was to get decided to settle amicably, but last occasion she refused to compromise the matter.
No, where are the reasons? Para?
Para 4, 5, 6, 7.
Yes.
Lordship, I am objecting the condonation petition, Lordship, because it is an inordinate delay of 220 days, Lordship, and unexplained, Lordship. And what the petitioner has said that on 1st October 2024, the order, impugned judgment and order was passed. And he came to know only on 15/6/2025, which is completely false because another matter, just learned friend has said, another title suit is pending and the applicant is participating in both the proceedings. And in the paragraph 5, he stated that he admitted that he has not corresponded with his engaged counsel after the argument was done in this matter, Lordship. So it also shows that negligence on his part, Your Lordship. And when the negligence is there, for 8 months, he is sitting tight over the matter. When negligence is there, Lordship, there are, Lordship, settled position, Lordship, that negligence should not be condoned. So delay, though liberally may be condoned, but such negligent, Lordship, one party should be vigilant about his right, Lordship. And it is admitted fact that he did not communicate with the engaged counsel for last 8 months. Though another matter is pending before the learned court below. So it is not believable that he don't know.
Which matter is pending?
Lordship, in their
Title suit.
memo of appeal also mentioned, and I have mentioned in my objection also. Paragraph 6, Lordship, I have mentioned. Paragraph 6, last subparagraph, subparagraph 3. Paragraph 6, start from page 62 of my objection, affidavit in opposition. Page 62, Your Lordship will find page 62, paragraph 6. In the next page, 63, the second paragraph, I have mentioned the case number. That is in the stage of official witness, evidence of official witness. And the case is next fixed on 12 on next 12, Lordship. So he is very much aware about the proceeding, Lordship, about what the matter, and it is not that
Now, how this title suit is linked?
Lordship,
How it is linked with
it
the,
led by him, Lordship,
no, how it is linked with the probate
because
case?
same property, Lordship, regarding same property, he is filed. Learned Fred also says that he has filed that,
My only condition is, my lord.
and there was no compromise
Title
as
should be filed.
projected, Lordship. There was no such compromise deed or anything. Nothing was done, Lordship. Only I have filed. I have the probate be granted by the learned court below, and they have filed.
What ground you are challenging the probate case order?
But this, my lord, will has been obtained fraudulently.
That's the ground.
Will obtained fraudulently. Property belongs to my father. They obtain another will. Say that my father gifted that land to my mother. Then my mother again executed will in favor of my sisters. Two wills are there.
But you have admitted your negligence
Yes.
in not corresponding.
Now, yes, my lord. Fact is, this case is concerned, since where talk is going on, I am not taking steps for filing the appeal in due time. This is the reason, because matter is still going to be settled. In title suit also, we are there. She is also party. That is also, but however, in this case, I have not taken step because talk is going on. This is the only reasons. That is why I am not consulted with my engaged counsel regarding this case, my lord.
Lordship, the
Only that, my lord.
pendency of that title.
You pay cost.
Lordship.
Subject to payment of cost, we will.
My lord, something 2000.
Heard Mr. J. Ahmed, learned counsel for the applicant. Also heard Mr. J. Abbas,
Obliged.
learned counsel for the respondent. This application, this interlocutory application under Section 5 of the Limitation Act has been filed by the applicant Shri Leeladhar Das, praying for condonation of delay of 220 days in filing the connected testamentary appeal, whereby the applicant has impugned the judgment and order dated 1/10 2024, passed by the Court of Learned Additional Session Judge Borpeta in title suit within bracket probate case number 3/2024. Learned counsel for the petition applicant has submitted that though the judgment in the title suit probate case number 3/2024 was delivered on 1/10/2024. However, the applicant had no knowledge about the same till 15/6/2025, when the engaged counsel for the applicant informed him about the same. Thereafter, some time was also consumed in obtaining the certified copy of the impugned judgment. He further submits that as the respondent is his own sister, hence there was an attempt of arriving at an amicable settlement between the parties. And as the talk of compromise was going on, the applicant did not make any correspondence with the engaged counsel to know about the status of the case. Stop. On the other hand, learned counsel for the respondent has opposed the prayer for condoning the delay on the ground that the applicant has failed to sufficiently explain the reasons for delay in filing the connected testamentary appeal. He submits that the averment made in the interlocutory application that the applicant came to know about the fate of the probate case only on 15/6/2025 is not true, as the applicant himself has preferred a title suit in respect of the same subject matter before the Court of London Civil Judge Junior Division number 2, which has stopped. The said title suit has been registered as title suit number 108/2019. It is also submitted by learned counsel for the respondent that from the averment made by the applicant in the interlocutory application, it is apparent that he himself was negligent in not pursuing the matter, as he has admitted that he did not make any correspondence with his engaged counsel. He further submits that the applicant may not be allowed to take advantage of his own negligence, and therefore he prays for rejecting the application for condoning the delay of 220 days. I have considered the submissions made by learned counsel for both sides and have gone through the materials on record. Though the applicant has pleaded that he was unaware about the date of disposal of the title suit probate case number 3/2024. However, it appears that he had filed a admittedly, however, it appears that he had admittedly filed an title suit in respect of the same subject matter. Stop. Though the plea that there was an attempt of reaching an amicable settlement between the parties has been denied by the learned counsel for the respondent, however, considering the fact that both the parties are brothers and sisters in relationship, the said plea cannot be totally ruled out. Stop. While it is a settled proposition of law that while considering an application for condonation of delay, the court should take a justice-oriented approach, and as such, considering the relationship between the parties as well as grounds taken in the memo of appeal and the reasons stated in the instant interlocutory application, by the applicant, which has caused the delay in approaching the court, this court is inclined to condone the delay of 220 days in approaching the court in filing the connected testamentary appeal. However, considering the circumstances as discussed in the foregoing paragraph, a cost of ₹5,000 is imposed on the applicant as a condition for condonation of delay. Stop. Accordingly, the delay of 220 days in filing the connected appeal is hereby condoned, subject to payment of cost of ₹5,000 by the applicant to the
Registry.
respondent. Stop. The cost shall be deposited by the applicant before the registry of this court within
10 days.
within
7 days.
within 7 days from the date of this order. Thereafter, on such deposit of costs, same shall be disbursed to the respondent by the registry, and the connected testamentary appeal shall be registered and listed for admission. This interlocutory application is accordingly disposed of.
I'm deeply obliged.
Also, as per office note dated 7/3/26, it is written that no steps are taken, Lordship, but we have taken steps, Lordship. There might be some difficulty in, there are two cases, Lordship. IA Civil 264/26 for condoning delay in filing restoration petition, and MC 3/26 is the petition for restoration, Lordship. So order is in, Lordship, in this case. So first orders would have been in the IA, Lordship, I think. Order
Yes,
is in miscase.
delay has not yet been condoned.
No, notice is issued, Lordship.
I am appearing on behalf of opinion number 1 to 5.
We have taken steps on 2, 3, but in delay petition, Lordship, there is no order. Order is in the miscase, Lordship. For this reason, Lordship, there might be some confusion, Lordship.
264 লিখিব।
264 is a petition for condoning delay of 113 days. Order is in, I think, Lordship, in the miscase for restoration.
This heard Mr. A.J. Saikya, learned counsel for the applicant. Also heard Mr. What is your name?
D. Doctor.
D. Datta, learned counsel appearing for
Opinion number 1 to 5.
1, 2, 3, 4, 5
Yes.
claimants.
Yes.
Respondent number 1, 2, 3, 4, 5 claimants, opposite party. This application under Section 5 of the Limitation Act has been preferred for condonation of delay of 113 days in filing the connected miss case for miss case wherein a prayer for readmission of MAC appeal number 40/2017 has been made by the applicant. It appears that when the matter was listed on 27/2/2026, a coordinate bench of this court has passed the orders on that day in miss case number 3/2026. Whereas before passing any such order, this interlocutory application is required to be disposed of. Where is the acknowledgement that you have taken steps? You take fresh steps. Learned counsel for the applicant has submitted that due to the aforesaid fact, there was some confusion in taking steps. Stop. The applicant is directed to take fresh steps for issuance of notice on the respondents by speed post as well as by usual mode within 7 days from the date of this order, returnable on 31st of March. Since Mr. D. Datta has appeared for respondent number 1, 2, 3, 4, and 5, no formal steps need to be taken. No formal notice need to be issued to the said respondents. You have received the copy of IA. However, as regards the other respondents, the applicant shall take steps as indicated herein above. List accordingly on 31st March.
Problems.
Item 12.
Service is not completed, Your Lordship. This has been taken.
What is your name?
Miss A. Chakraborty.
Heard Miss A. Chakraborty, learned counsel for the applicant, appellant. Also heard Mr. T. R. Gogoi,
6 and 7.
learned government counsel appearing for respondent number 6 and 7. The notices issued to respondent number 1 to 5 have not returned. Stop. The registry is directed to place postal track consignment report of notices issued to respondent number 1 to 5 on the next, before this court on the next date fixed. Let this matter be listed on 23rd of March.
Item 13.
What if this IA has been filed for allowing us to withdraw the amount deposited?
Any objection?
So I have filed objection.
They have filed their objections, Lordship, already.
What objection?
They have filed the appeal bringing one GD entry, Lordship, which was never brought the part of the record during trial. If Lordship goes to the only appeal memo, original appeal memo, Lordship. As well as here in the. They have not given their annex here in their objection, but in the appeal memo, Lordship, they have annexed it one GD entry.
What is the GD entry?
Lordship, the case was filed under section 166 of the MD Act, Lordship. Lordship, they have completely filed a false case, Lordship. As per the GD entry, so kindly see the GD entry, Lordship. Page number 13 in my memo appeal, Lordship.
That GD entry has been filed only in the appeal, Lordship.
They have,
During trial,
they have suppressed before the trial court. That is why we have placed before this court. Lordship, kindly see the GD entry number. GD entry number 96.
Unless you bring this GD entry on record. This.
Yes, Lordship, I have produced in before the trial court, Lordship, before the high court, because they did not prove that the.
No,
it was
suppose something was not before the trial court.
No, they have suppressed, Lordship. There was nothing.
they have petitioned in the trial, Lordship.
Lordship, they did not examine
Yes,
any
charge
eyewitness.
sheeted.
They did not examine any eyewitness. They have filed a false FIR, Lordship. That is why at the time of admitting an appeal, Lordship.
No, why you did not agitated these things?
Lordship, kindly see the order dated 4/1/2017 in IAC number 1799 2016. Lordship.
That is a deposit.
No, Lordship, that is
Okay, this fact we will decide in the appeal.
that is why, Lordship, after servicing the notice of respondent number 5, respondent 5, the case may be finally heard, Lordship. If they are entitled, they will get the whole money, Lordship.
Once the court has directed to deposit them after considering the facts of the appeal, Lordship, and the grounds of the appeal, then the court has directed them to deposit 50%. That was long back in 2017, Lordship. And
They are not allowed
learned
to-
friend is saying that no eyewitness. May I draw your attention to the judgment of the trial court, Lordship?
No, what are the facts? How accident occurred?
As per the
Why-
GD entry, Lordship, as per the GD entry, Lordship, kindly see the facts, Lordship. As per GD entry 91 and reported the matter in the police station that today is at about 2:30 PM in the land of the Muhammad Hamdaun Islam, son of Muhammad Asar Ali of village Lesabari, where Mujauddin, son of Mujibur Rahman, with the help of another boy, was plying with a tractor. Then at that moment, a boy named Musadul Islam, aged about 27 years, was trying to board on the running tractor by jumping from the front side. And as a result, he slipped and fall in between the tractor and the plying bed. And as a result, his body was cut into pieces. Thereafter, according to the investigation, an inquest report was done over the dead body of the deceased, and the pieces of the body was kept in the jute bag, and the said pieces of the body was sent to the hospital for PM report in vehicle to Morika, along with the UBC 169 and the family of the deceased. As per the said info, the GD entry was made. Lordship, as per the PM report also, it was not that due to the vehicular accident, Lordship.
That is,
Whole body was smashed, Lordship.
the entire case, Lordship, is based on just surmise and conjecture, Lordship. Nothing has been brought on during trial record. Lordship, you go through the judgment, Lordship, impugned judgment, Lordship.
No, what was your plea before the?
That a tractor hit us from the back. When we are returning home, tractor hit us on the back.
Okay.
That is why no
Persistent
such thing was
injuries?
trial, Lordship. The distortion of the fact, Lordship.
That is the
Distortion of
eyewitness,
fact,
you have given the
Lordship.
eyewitness during trial also.
It's a public money,
They have
Lordship.
cross-examined us.
It is a public money, Lordship.
No, if it is public money,
It does.
what you were doing when the inquiry was going on before the tribunal?
Lordship, the GD&T was not placed by them, Lordship.
Why I will place the GD&T? What is my requirement? Lordship? I have placed the form 54, that is my requirement.
Also,
Lordship.
accident report.
I have given the eyewitnesses, Lordship. And that has been mentioned in the
Whether
judgment
should
also, Lordship.
encourage the such like false cases, Lordship?
They have contested the case. What they are doing there? If the GD&T that they have
Hearing the
No.
appellate courts of the 2 days, right?
Whether appeal is ready for hearing.
Yes, Lordship.
Not,
After servicing the.
not yet, Lordship. They have not served within 7 years. They have not taken steps of notice. on
Yes,
the-
Lordship.
that
I have
one of
taken
the file.
step, Lordship. I have taken step.
Steps on the 20th February, Lordship. After 9 years.
Oh, where,
After 9 years, they have taken the steps
where is
on the
the
owner.
where is the decision of the
Lordship, judgment, impugned judgment,
impugned
Lordship.
judgment
At page 19, Lordship. Sorry, page 18.
of the
Appeal, they have annexed to the
Lordship,
MSc
the
appeal.
appeal may be finally heard, Lordship. At this stage, the Lordship may not be allowed to withdraw the 50%, Lordship.
And the appeal,
If the service is not complete by this way, Lordship, as we have taken by speed push, then even in the paper publication, we can do it.
internal page 3 of the judgment, Lordship.
yes.
Paragraph 4, in this case, PW3, Habibur Rahman is an eyewitness. He accompanied deceased Musahidul Islam at the relevant time, according to him, on 6/12/2010 at 2 p.m. along with the deceased Musahidul and the Abdul Ali were going towards the house of the deceased on foot from Gagalmari, Asigor, while they were on the road on the other side, the offending tractor under registration number this and this coming from Gagalmari going towards Lochonagori, being driven by it at an excessive speed in a rash and negligent manner, hit the deceased from the behind. This is our pleaded case. This has been supported by the eyewitness, and they have not brought anything on during trial, during inquiry. No DW.
You give indemnity bond.
Definitely, Lordship.
If ultimately it is found that you are not entitled, then
We will return back the money, Lordship.
Mr. S.K. Poddar.
Lordship, I have another prayer, Lordship. This money was deposited long back in 2017, Lordship. Money is lying with the registry in an interest earning account, Lordship. So whatever the interest registry has earned, it may be returned to us, Lordship. Maybe 2.7% or 3%, Lordship, in this between part.
No, that will be decided ultimately.
Again, once released, Lordship, normally that part goes on the behind, Lordship. So 4.5 lakhs they have deposited, Lordship. In my
No,
petition, I have mentioned.
heard Mr. S.K. Poddar, learned counsel for the applicant / claimant. Also heard Mr. K.K. Bhatta, learned counsel for the insurance company respondent. This interlocutory application has been filed by the applicants, claimants, praying for directing the registry to disburse when this appeal is filed in the year 2016,
Lordship.
why it has come up after 10 years?
Lordship, since the court was not allowed to withdraw the amount, they have sent the advocate, Lordship.
No, Lordship, never,
They
no
have
prayer
changed
was
the
made,
advocate.
Lordship. No prayer was made, Lordship, that amount,
Lordship,
that is not a wrong submission, Lordship.
that is the facts, Lordship.
That is a wrong submission, Lordship, because that order was passed, stay order was ex parte, Lordship.
Where is the refusal of the court?
No, nowhere, Lordship. You have
Because
never
Lordship,
approached, Lordship.
earlier, the different set of advocate was appeared.
They have
for the
never
claimant,
informed the
Lordship.
petitioner.
No, but order sheet, where is the
Lordship,
the order that court has refused to disburse the
Right, Lordship, where is the question of refusal, Lordship? They have taken the stay order ex parte. My earlier counsel
Kalika,
have not
Amita
informed.
Kalika. disburse the 50% of the awarded amount which has been deposited by the appellant insurance company in pursuant to the order dated 4/1/2017 passed in the interlocutory application number 1799/2016 by this court. Learned counsel for the applicant has submitted that the applicants / claimants were awarded compensation amount of rupees 9 lakhs along with an interest at the rate of 8% per annum for death of their son / brother in a vehicular accident, by the judgment and award dated 20/4/2016 passed by the Motor Accident Claims Tribunal, Morrigan. He submits that the appeal preferred by, and he submits that the execution of the aforesaid judgment and award was stayed by this court by its order dated 4/1/2017 passed in IA number 1799/2016, subject to deposit of 50% of the awarded amount by the insurance company, and accordingly the insurance company has deposited the same before the registry of this court in the year when it has
31/1/2017, they have deposited.
on 31/1/2017. Learned counsel for the applicant submits that since the applicants / claimants were the beneficiaries of the award which has been impugned in this case, in this appeal, in the connected appeal, and since because of the filing of the appeal, they have been deprived of the benefit of their award for last 10 years, they may be allowed to withdraw the 50% of the awarded amount deposited by the insurance company. Learned counsel for the applicants further submits that the applicants are ready to furnish an indemnity bond to that effect also. On the other hand, Mr. K.K. Bhatto, learned counsel for the insurance company, has vehemently opposed the
Number 3 and 4 of them, my objection.
vehemently opposed the prayer made by the applicants. He submits that the appeal preferred by, he submits that there is every possibility that the appeal preferred by the appellant insurance company may be allowed. And in such a case, if the 50% of amount is disbursed to the claimant, it would be difficult to realize the same in the event of an favorable order passed in the appeal. He further submits that the GD entry number 91, 92, and 96 dated 6/12/2010 of the Mayang police station, which was never produced by the claimant before the Motor Accident Claims Tribunal, clearly shows that the accident had occurred solely due to the negligence and fault of the deceased himself. Stop. I have considered the submissions made by learned counsel for both sides. The plea taken by the insurance company is required to be examined in the connected appeal. However, this appeal is pending for last 10 years, and for such a long period, the claimant may not be deprived of the benefit which was granted to them by the Motor Accident Claims Tribunal. More so when they are ready to submit an indemnity bond for depositing the amount which will be given to them in the event of the appeal going against them. So, under such circumstances, this interlocutory application is allowed. The registry of this court is directed to disburse the 50% of the awarded amount deposited by the insurance company to the claimants after proper verification, subject to furnishing of an indemnity bond, whereby indemnity bond of rupees 4,50,000, wherein an undertaking shall be given by the claimants that in event the connected MAC appeal number 309/2016 going against them, they shall deposit back the said amount to the court. With above observation, this interlocutory application is disposed of. And what is there in the main case?
Service please, I can respond about 5.
Registry have directed to track the record, Lordship, for speeding up the process.
When have you?
They have taken mostly on 25 or 20 February.
Service
On the owner.
you take fresh steps.
Recently it was taken.
They have recently taken.
When?
Maybe on 23rd of February or note sheet is there, order sheet is there.
Okay. Third, Mr. K.K. Bhatta, learned counsel for the appellant. Also, Mr. S.K. Poddar, learned counsel for respondents / claimants. It appears from office note that though the notice to respondent number 5 has been issued by speed post on 20/2/2026, no service report has been received. Stop. The registry, next para, the registry is directed to place the postal track consignment report of notice issued to respondent number 5 by speed post before this court on the next date fixed. Let this matter be listed on 23rd of March.
Item 29 from supplementary list.
As per Office for the 7/3/2026, LCR not received. And SR on respondent number 6 is not received. 6 and 7. 6 and 7. Also, we may take a paper publication on 6 and 7.
Who are 6 and 7?
6 and 7 are the owner and driver.
You can take steps through speed posts.
Speed post lordship are already taken long back, so it was not charged. So we may take a paper application. That will be better.
Okay. Heard Mr. S.K. Goswami, learned counsel for the appellant. Also heard Ms.
P Bodler for K Bhattacharya.
P. Bordole, appearing for respondent number
1 to 5.
1, 2, 3, 4, and 5. On perusal of the office note dated 7/3/2026, it appears that the records of MAC case number 329/2011, which was called for in connection with this case, has not yet been received. Stop. The registry to issue reminder for the same. Stop. It also appears that notice issued to respondent number 6 and 7 have also not been returned. Stop. Learned counsel for the appellant prays that the appellant may be allowed to take steps by substituted mode of publication of notice in two newspapers.
In Gauhati, lordship, that is one is told.
Two newspapers widely circulated in the area where the respondent 6 and 7 were known to have resided. Stop. The prayer is allowed. The appellant shall take steps for issuance of notice on respondent number 6 and 7 by substituted mode of paper publication in two newspapers within 15 days from the date of this order. The date of notice to be, date of appearance to be mentioned in the notice shall be 22nd April. 22nd April. List this case after the said date.
We'll file an affidavit after publication.
Lordship, Mr. K Bhattacharya's name is now reflected in the cause list.
Registry shall reflect the name of Mr. K. Bhattacharya as the engaged counsel for respondent number 1, 2, 3, and 4. 1, 2, 3, 4, and 5. Henceforth.
Interim order to continue, lordship, till returnable date.
What interim order?
Regarding stay of the judgment.
The interim order shall. Interim order granted in the interlocutory application. Interlocutory application number 2320 shall continue till next day.
Published.
Please, Your Lordship, as per office note dated 7/3/26, LCR has not been received, but it is from 2020, Lordships. Otherwise, service is complete. So reminder may go for LCR now.
Heard Ms. R.D. Majumdar, learned counsel for the appellant. Also heard Mr. M. Talukdar, learned counsel for respondent number
1 to 5.
1 to 5, as well as Mr. S. Datta, appearing for respondent number 6 to 9.
6, 7, and 9.
6,
7 and 9.
8.
8 we are not representing.
Lordship, 8 is also from your family. You're not. 6 to 9 it seems.
But earlier you represented it.
6 to 9 they represented.
Earlier in 2020 also.
But Your Lordship, in the Vakalatnama, we are representing only 6, 7, and 9.
Then
But they are from the same family.
Same family, Your Lordship, but
no, but this you should have pointed out, because in the year 2020,
Yes.
as well as
Your lordship, I heard that respondent number 8 has expired. Regarding that, we'll have to take instruction whether.
Who is it? Who is it?
Son
Son of Prasikal, he's son of the
deceased.
deceased. He had two wives, lordship, so 1 to 5 are one set of wife and children, and 6 to 9 are one set of children, wife and children.
Lordship, let him take instructions whether he expired.
Then there may be a necessity of substituting.
No, if
Other legal heirs, other
other
parties.
legal heirs are there, then because
Learned, Mr. S. Datta, learned counsel for the respondent has submitted that that respondent number 8 has expired and he needs some time to take instructions regarding the date of his death as well as the legal heirs of the said respondent. The prayer is allowed. Let this matter be listed. No. 22nd of April. The registry shall also issue a reminder for the records of MSC case number 1594/2010. List accordingly.
Silchar, MACT Silchar.
From MSC, from Motor Accident Claims Tribunal, Kachar, Silchar.
Okay.
Item 31. My lord, the respondent filed application for release of the 60% awarded amount.
How much?
60%, my lord.
How much was deposited?
See, as part of the direction was given to deposit 50%, they will be allowed to withdraw the deposited amount. I have to take it, sir, whether same was deposited or if
My
same
lord-
was not deposited.
Whether it was deposited or not.
So far the record is concerned, it is not deposited. The order was passed on 20/12/2024.
If it was not deposited, let's say within this week, it will be deposited and they may be allowed to withdraw 50% of the amount.
From the registry of the High Court.
No, first let them deposit. If they don't deposit, then there will be no stay. Then you may go for 100% execution.
It may come next week, let's say. I have taken instruction.
Okay. No, you deposit by within 7 days.
By a single stroke, by phone, might he can get it confirmed,
Within 7
whether
days.
it was
Oh.
deposited or not. 2024 orders.
This interlocutory application heard Mr. A.R. Talukdar, I.A. Talukdar, learned counsel for the applicant. Also heard Mr. K.K. Bhatto, learned counsel for the insurance company. Though this application has been filed by the applicants / claimants for disbursing the amount deposited by the insurance company before the registry of this court in pursuant to the directions of this court. However, Mr. K.K. Bhatto, Mr. K.K. Bhatto, learned counsel for the learned counsel for the insurance company submits that he is yet to confirm that as to whether the amount has been deposited or not, and he seeks a week's time to find out the same. He also submits that if the amount has not yet been deposited, the insurance company shall do so within a period of a week,
7 days.
7 days time. In considering the submissions made by learned counsel, let this matter be listed again on 20 March.
Yes. My lord, analogous case, same case, my lord. MSc appeal number 53724. Maybe tagged with this. Same accident, same 53724.
MEC appeal to sir.
Same out of the same party, same insurance company, my lord. Mr. K. Body is the leading counsel, my lord. Yes, apna.
It can be taken with the, as per.
No, you have to also take steps for issuance of notice. Heard Mr. K.K. Bhatta in appeal. The learned counsel for the appellant. Also heard Mr. I.A. Talukdar, learned counsel for respondent / claimant. Respondent number 1 / claimant. On perusal of the office note dated 7/3/2026, it appears that the notice issued to respondent number 2 and 3 have returned back without service with postal endorsement within inverted comma. No such person comma insufficient address inverted comma close. So against respondent number 2 and 3, you have to take fresh steps.
To take instruction.
Learned counsel for the appellant seeks a week time to take necessary instruction regarding proper address of respondent number 2 and 3. The prayer is allowed. Let this matter be listed on 20 March along with MSc appeal number
537/2024.
537/2024.
Obliged. You ready? Item 14.
Main feature lordship.
Yes.
Lordship, this appeal is filed by the Lordship Insurance Company Lordship against a judgment dated Lordship. Against a judgment dated 15/5/2013 Lordship, passed in MSc case number 2008/2009. Here, Lordship, we have filed this appeal mainly on the ground that Lordship, it's a case of contributory negligence, which was not considered by the learned tribunal Lordship. And Lordship, one of the main ground is the income Lordship. There is no precise proof of the income of the disease.
Okay.
I'll take a Lordship to the judgment Lordship. Well, okay, two vehicles are involved in the accident. One was driven by the disease, the car, and the other one is a truck. I'll take a Lordship at page 162, the judgment Lordship. Starts from page 6, Lordship. Starts from page 6.
Yes.
Second Lordship, judgment and order starts from page 7. May I read, Lordship?
Yes.
This claim case arose out of a petition under section 166 of Motor Vehicle Act and we have filed by the claimants claiming compensation of ₹1 crore from the OP on account of the death of the deceased Rajesh Datta in a motor vehicle accident. Case of the claimants in brief is that on 29/11/2008, the deceased was proceeding from Dibrugarh side by the vehicle bearing registration number so-and-so by the extreme left side of the road towards his residence, and when he arrived near Silkati T State, one vehicle bearing registration number AS23E1694 truck, which was proceeding from opposite direction in a rash and negligent manner, knocked down against the deceased vehicle. As a result of the disease, sustained grievous injury on his person and died on the spot. The claimant further stated that the deceased at the time of accident was a businessman and used to earn ₹75,000 per month. The accident occurred under the Sabua PS. According to OC Sabua PS, registered a case as Sabua PS case number so-and-so of IPC to 79304 IPC and started investigation. During course of investigation, police sent the dead body of the deceased for conducting postmortem examination by the doctor, and accordingly postmortem was conducted by the doctor on the dead body of the deceased. The OP number 1, 2, and 3 submitted their written statement to contest the case of OP 1 and 2 by filing written statement denied almost all the elements of the claim petition. They stated that at the time of accident, the offending vehicle truck was under valid insurance policy and the driver had a valid driving license. They have further stated that there was no rash and negligence driving on the part of the driver of the offending vehicle at the time of driving the vehicle. The OP number 3, Lordship, here is the appellant insurance company, OP number 3.
Okay.
OP number 3 in the written statement stated inter alia that the accident occurred due to head-on collision between the two vehicles, that there is a violation of the statutory provision of the AMBI Act and breach of policy conditions, and as such prayed to pass the award against the owner of the vehicle. OP number 3 denied the age, occupation, and monthly income of the deceased, stating that the claim amount is exorbitant. OP number 3 further stated that the insurance company shall not indemnify the owner if at the time of accident the vehicular documents are not found to be valid. On the pleadings of the parties following are framed. Here, Lordship will find the OP number 4 was also made party in the claim proceeding, Lordship. OP number 4, the insurer of the car, which was driven by the deceased, Lordship. And there is no finding regarding the status of the OP number 4. OP number 4 is the insurer of the car, which was driven by the deceased and was made party as OP number 4. The Bajaj Alliance General Insurance Company Limited.
Okay.
Then we have filed written statement on the pleadings of the parties following issues are framed. There is no finding regarding the status of the OP number 4. Issues were framed whether the victim Rajesh Datta died as a result of injuries sustained by him in the alleged road accident dated so-and-so involving vehicle number AS231694, that is a truck, and whether the said accident took place due to rash and negligent driving of the driver of the offending vehicle, whether the claimants are entitled to receive any compensation, and if yes, to what extent and by whom amongst the opposite parties the said compensations amount will be payable. 6, in course, so then these are the issues, Lordship, framed. The main issues regarding contributory negligence that was not framed by the learned trial.
Whether you, in your written statement, you have taken.
Yes, Lordship. I have taken this plea, specific plea was taken. Yes, sir.
Where?
I have taken the plea WS by NIA page 26 of the lower court record, Lordship. That is, Lordship, reflected in the judgment also.
Judgment where?
That is, I have gone through, Lordship. The OP number 3, Lordship, that is the appellant insurance company, Lordship. In page number 8, Lordship, second line. The OP number 3. Lordship got, I think.
Yes.
This is the appellant insurance company. We have filed appeal, Lordship. OP number 3 in their written statement stated inter alia that the accident occurred due to head-on collision between the two vehicles, and there is a violation of statutory provision of bail. And we have also specific plea was there at page 26 of the lower court record by Lordship, WS by the appellant insurance company.
Yes.
Lordship, then my continue Lordship. Then Lordship, this issues frame Lordship, but this regarding issue of contributory negligence that was not framed by the learned tribunal Lordship.
Okay.
Then Lordship, in course of hearing, next Lordship,
Yes.
in course of hearing, the claimant's side has examined two witnesses. By filing evidence on oath and contesting opposite party insurance company has cross-examined the claimant's witnesses. The contesting opposite party insurance company has not adduced evidence. I have heard argument from both the sides orally and documentary and carefully gone through the evidence on record. My findings in respect of the above noted issues, in view of the evidence on record and in the light of the submission of the learned counsels from both the sides are as follows. Issue number 1, the claimant CW1 has averred in the claim petition and also stated in her evidence that on 29/11/2008, her deceased husband Rajesh Datta was proceeding by the vehicle bearing registration number A01AD5077 by the extreme left side of the road from the Brugger side towards his residence, and when he arrived near Silkati T-State, one vehicle bearing registration number so-and-so truck, which was proceeding from opposite direction in a rash and negligent manner, knocked down against the deceased vehicle. As a result, the deceased sustained grievous injury on his person and died on the spot. She further stated that the deceased at the time of accident was a businessman of hardware goods fertilizers, as well as distributor of fertilizers in the Upper Assam area in the name of Style and RD Enterprise, and his annual income was so-and-so 5 lakhs to 470 from his business. The further evidence of the claimant is that the accident occurred under the Sabua PS, and accordingly Sabua PS registered the case Sabua PS case number so-and-so and started investigation. In completion of the investigation, police filed charge sheet against the driver of the offending vehicle. She started in her evidence, in support of her evidence, the CW1 proved the accident information report by the Exhibit 1, postmortem examination report by the Exhibit 2, PAN card by the Exhibit 3, income tax return by the Exhibit 4 and 5, and the copies of FIR, search sheet, and seizure list by the Exhibit 6, 1 to 2. In cross-examination, she stated that she has not seen the accident. She also stated that at the time of accident, her deceased husband was driving his vehicle. She denied the accident occurred due to fault of the deceased. Here, Lordship will find this accident information report. Accident information report, Lordship will find in the lower court record, Lordship, where in the claim petition also, in the accident information report also, Lordship, both the vehicles are involved in the accident. In the accident information report, both the vehicles, the car and the truck, mentioned, Lordship. And in the FIR also, the claimant, right, on the page. FIR also, Lordship, the claimant stated that it was a head-on collision between the vehicles, Lordship. I continue, Lordship. The claimant has examined one more witness to prove the case, Amol Gorfalia, SCW2, Lordship. He stated that he is the eyewitness to the accident. He stated in his evidence that on the alleged day of accident, he was proceeding from Lohal side towards his residence at Hatiali by a Maruti car along with two persons, namely Rambi Radhav and Sri Raju Sangmai, and saw that one vehicle was driven by the driver in a very rash and negligent manner, coming into the wrong side, knocked down the deceased vehicle. He further stated that the offending vehicle knocked down the deceased from his front side. Thereafter, they went to spot and found that there was an iron rod pierced in the right side of the chest. Thereafter, the injured succumbed to his injuries. He further evidence is that the accident occurred due to rash and negligent driving of the driver of the truck bearing so and so. But in the cross-examination, your lordship will find in the cross-examination, he was proceeding with two friends, lordship. But the lordship will not find the lower court record on the cross-examination part, lordship. That is not there.
Where will we find?
Lordship, may kindly say it was, I think it was not print, it was print, it has gone, lordship. Only the signature is remain, lordship, in the lower court record. Lordship, may kindly peruse this. In the record, lordship.
Now,
The cross-examination part of the claimant as well as the cross-examination part of the eyewitness. This is not there, lordship. That is not there.
it has faded out because of time.
Yes, lordship.
Now,
Okay,
now
my-
what is your submission?
My learned friend have obtained the certified copy.
That will do.
That will help.
If you have certificate
Yes,
copy,
yes.
we'll rely on that.
That is why I'm saying,
You furnish that certificate copy
lordship,
to court after you make your submission.
lordship.
We'll rely on those. What you want to say?
I want to say that, lordship, the PW2, the eyewitness, lordship, he was going with two friends behind the Maruti car. And it was a foggy night, lordship. In the cross-examination, he said, may I read the cross-examination?
Yes.
Yes. I have not mentioned the age of the claimants in the.
What,
No.
what portion you want to rely?
Small cross, lordship. Small
Okay,
cross.
read.
Small cross. One paragraph. Accident took place near my house. Place of accident is National Highway. It is not a fact that there was no road divider while proceeding. Vehicle at the deceased was proceeding ahead of the vehicle. There was foggy night and the vehicle was not in speed. There was a foggy night. It is not a fact that I have deposed falsely. It is not a fact that I have not mentioned correct time of accident in my affidavit. It is not a fact that the driver of the truck had no fault. Police took my statement. It is not a fact that I have not seen the accident. Here, lordship, he was going with the two friends. That two friends were not examined before the learned tribunal. The friends along with him, and it was a foggy night. It is admitted, and the time is mentioned.
You are emphasizing foggy night. What you want to say?
That means
That
it's a,
may-
both vehicles. It's a head-on collision because it may happen.
No.
He admitted himself.
The CW2 has also said,
Yes.
deposed that the offending vehicle came on the wrong side and then hit the car of the
Yes, yes.
deceased. So there may be head-on collision, but every head-on collision does not indicate that there is contributory negligence. Merely head-on collision would not result into a conclusion that
But that is not the case of the claimant, lordship. From opposite direction it came.
no. Claimant has read page 4. The driver in page 9.
Lordship.
The driver in a very rash and negligent manner
Yes.
coming
Yes,
into
that
the
of
wrong
the
side.
residence when he arrived.
Coming to the wrong side. You have not
Proceeding from opposite
counted
direction.
this.
Proceeding from opposite direction, knocked down against the deceased vehicle. This is at, lordship will find it page 9, paragraph, I think, 8.
No, read para 9.
Yes.
Para 9. Last line.
Let us examine one more. He stated that he was very insurance.
Page 9, last
Yes,
line.
yes. Yes, last line, that's driven by the very Rasan negligence coming into a wrong side.
Coming
That
into
is-
wrong side.
Yes, yes.
So
So
this
this-
coming to wrong side is supports his case.
No, Lordship, my submission is that Lordship, in the cross,
Ah.
he has stated.
That there was fog.
Yes, yes, fog because of that, the vehicle was not in speed and it is not affected. I have deposed for that fog, because of fog, maybe how he can see. Wherever it is, whatever it is, Lordship.
There is no further questioning that because of fog, there was no visibility.
Yes, that is there, Lordship. Whatever it is in the record, I have
Okay.
taken, Lordship.
Your main case is that as because there is head-on collision, so court should have
Contributed, yes, at least.
come to a
it may be
conclusion that
considered.
contributory
Yes,
negligence.
that finding is not there. That finding is missing, Lordship.
Okay.
Whatever it is that has to be discussed, Lordship. That has to be considered because that is the issue, should be main issue, Lordship.
Okay.
And overall, Lordship, that the OP number 4 was made party as a OP insurance company of the said vehicle, Lordship, the car. They have not filed any written statement, no pleadings, nothing. In absence of that, Lordship, no pleadings, no cross, nothing, Lordship.
So what? What is your submission?
My submission is that if they have the point that they are not liable, or even then they are not wrong, then they ought to have pleaded like that, Lordship.
Suppose they have not pleaded, then what conclusion? court
Then,
may-
Lordship, issues should be framed on the basis of that issues that may be considered at this, Lordship.
Oh, that is okay, that
finding
the
is not
court,
there, Lord.
court failed to frame
Yes.
an issue regarding contributory negligence.
Yes, Lordship. And therefore, Lordship, there is no absence of, totally absent that part, Lordship. Then
Okay.
I'll continue, Lordship. Next judgment is remaining, Lordship.
Yes.
Lordship, this paragraph 11, Lordship.
Para 10.
Yes, para 10, Lordship. Now let us go to decide whether the accident took place due to rash and negligent driving of the vehicle number truck or not. From the evidence of the CW1 and the other documents submitted in this case, it is clear that the deceased died due to the injuries sustained in the motor vehicle accident. As per accident information report, which was issued by the OC, PS vehicle number truck was involved with the accident. The CW1 claimant in her evidence stated that on the day of accident, her husband was driving his vehicle. She also stated that driver of the offending vehicle drove the same in a rash and negligent manner and hit the deceased. On the other hand, CW2, who is the eyewitness of the accident, stated that the deceased was hit by the offending vehicle coming into the wrong side. He further stated that the driver of the offending truck hit the deceased from his front side. He also stated that the offending vehicle was driven in a rash and negligent manner and the accident occurred due to fault of the offending vehicle, that is truck. From the above noted evidence, it is appeared that there was negligence on the part of the driver of the vehicle, so and so. I have gone through the police report, FIR and search sheet. The opposite party side did not adduce any rebuttal evidence. So far, the rash and negligence driving of the offending vehicle was concerned. In view of the above evidence of the claimant and in absence of any legal evidence, it is crystal clear that the accident took place solely due to rash and negligent driving of the offending vehicle number, the truck. And the injured sustained injury in the said accident and died later on. Hence, this issue is decided in favor of the claimant side. Then this issue regarding income.
Lordship, I tender my apology in interruption, my lord.
Yes.
Lordship, item number 20, my lord, today's this, my lord. My lord, that matter was referred to mediation. Mediation was successful, my lord. So on the basis of mediation report, case may be disposed of perhaps, my lord. Mediation was successful, my lord.
Mediation report has
Come, my.
come.
It is
Take
there.
C, Lordship. Take mark C.
Okay, we'll dispose it of.
My lord, my lord.
Today, if your matter don't reach, then also we'll dispose it of.
Fine.
We'll reflect your name. In terms of the report of mediation, it has to be disposed
Yes.
of. Okay.
Much.
What is your name?
A Hussain for respondent number 1 and 2. Lordship.
Okay. We'll show it as disposed of.
My lord.
My lord.
Yes,
May
miss.
please, your lordship. The last part remains, lordship. Regarding lordship, page number 6. Lordship, issue number.
Issue number 2.
Issue relates to relief and reliefs to be granted to the claimants to its extent. Now, coming in the question of compensation, I find the claimant claimed rupees 1 crore. For assessing the compensation, the claimants are required to establish 3 things in the instant case: age of the disease, income of the disease, number of dependents. The claimant number 1 stated in the claim petition that the age of the disease, her husband at the time of death was 35 years. On the other hand, in the PAN card, the date of birth mentioned is 27/3/1973. According to the deceased was about 35 years, 8 months, 2 days at the time of his death. As per the decision of Sarla Burma, Assembly Address, Delhi Transport, the age of the age group 35 to 40 is 15. In view of the above age of the disease, multiplied 15 has to be taken for ascertaining the loss of dependency in the instant case as per so. Coming to second component, the claimant deposed that her deceased husband was a businessman who used to earn rupees 75,000 per month. In this regard, she submitted the income tax return as well as trade license of the deceased by Exhibit 425. So far, the third component is concerned, the deceased left behind 3 dependents, claimant's son and his mother as per claim petition. Further is not considered as dependent as decided in the above case. Actual income of the disease as the time of death should be considered. Hence, the assessment of the compensation in details for the year 2008-2009. Lordship, this the certificate of the income tax return is there, Lordship. 2008-2009, and according to 2008-2009 assessment year, gross income was taken as 6,06,424. And Lordship, next, the annual income of the disease, 5,02,470. After deducting 1/3, it came to rupees 3,34,980. Then accepting multiplier 15, the compensation came to rupees 50,24,700. Thus, taking the annual income of the deceased of rupees 3,34,900 and applying multiplier 15, the loss of dependency is rupees 50,24,700. The claimant has also claimed for future prospect in the light of the judgment passed by the Honorable Supreme Court, Santosh Devi versus so-and-so. Hard argument of both the side in this division bench judgment, Honorable Supreme Court has held that in para 18 of the judgment, rather it would be reasonable to say that a person who is self-employed or is engaged on fixed wages will also get 30% increase in his annual income, total income over a period of time. And if he becomes victim of accident, then the same formula deserves to be applied for calculating that amount of compensation. In view of the above discussion, I am of the view that since the deceased was aged about 36 years at the time of his death, and as per his income tax return, it could be seen that he was an established businessman. In view of the above 30% is awarded to the total income of the deceased as compensation towards future prospect. The future prospect is Lordship assessed accordingly, 30% adding 30% future prospect 1,04,994, and accordingly it came to 15,07,410. Besides loss of dependency, the claimants are entitled to funeral expenses as well as some amount of general damage. Thus, the just and reasonable compensation to which the claimants are entitled to is assessed under the loss of dependency 50,24,700, future prospect 15,07,410, then funeral expenses 5,000, loss of consortium 5,000, 2,000, loss of state and transport, totaling rupees 65,46,000, Lordship. Here, Lordship, then ordered OP number 3 and was under valid policy coverage at the time of accident is not in dispute. Hence, OP number 3 is to satisfy the award to the claimants. This issue decided accordingly. Order in the result of the claim petition is partly allowed. Claimant number 1 awarded total compensation of rupees 65,46,000. 46,000 for the death of her husband, Rajesh Dutta, in a motor vehicle accident. OP number 3, New India Insurance Company Limited is directed to pay the awarded amount to the claimant within a period of 90 days from today, that is on 15/5/13. The amount compensation carry an interest 6% from the date of filing of the claim petition till payment. Then this is the sharing of the upon the dependents lordship. So in this regard, my humble submission is that the income assessed by the learned member is not lordship, is not convincing at all lordship, since they have failed to prove the income tax documents lordship, the returns. Whereas lordship, the income tax documents lordship will find at that in the lower court record lordship. Considering the assessment year lordship, exhibit 4 and 5 lordship.
Yes, what you want to say?
It is income tax return. These are exhibit 4 and 5. It was exhibited lordship. It is in the record only. And as per that, returns lordship was not proved by the authority before the tribunal lordship. And above all lordship, this for the year 2008-2009, it was taken after 5,02,470, and then annual income of the disease was taken as 3,34,980. And lordship, my humble submission in this regard, they are still lordship, the business, the source of income is the business lordship of the disease. And as per assessment year 2008 to 2009, 2010 lordship, which was submitted by the claimant, it appears that lordship business is still their lordship and income is also their lordship. In 2009, 2010. The precise income is not proved, lordship. Claimant failed to prove the precise income, annual income of the deceased lordship.
Who filed the returns on 2009, 2010?
By the wife lordship. Lordship, may I kind-
Whether it was exhibited?
Lordship, that is, I did not find, I know lordship, but in this regard, lordship, I'd like to pray for filing it before this honorable court
No, that stage is over.
by way of an additional evidence, lordship. Order 41.
This you should have prayed earlier before.
Since this case was dealt by some lordship because of the expired lordship, thereafter that I have been engaged. All along with him in the last, only I have received it. This is the latest lordship, 2009, 2010, where the business is still there, lordship. And
The name of the SSC has been shown as.
in the next page, lordship. The next assessment. Gitanjali, the wife of the deceased lordship.
You give a copy of this to other side, what they have to say.
Lordship.
What else is your submission?
That is why, lordship, so my humble submission is that lordship, still there is income lordship and business is still going on. Therefore, there is no doubt there is a notional loss of income lordship, but there is some income is there, lordship. It appears the income is there, business is going on, lordship. And secondly, lordship, regarding head-on collision between the vehicles on a foggy night with the car, that is my humble submission. And lordship, so far as eyewitness, I just want to repeat the eyewitness part, lordship, because I will serve the copy, the certified copy of the eyewitness part, the cross. Lordship, may kindly see that the PW2, Lordship. PW2 is the eyewitness. Lordship got it in page 167 is written there.
Yes.
Omol, Lordship. Omol Gorfolia, Lordship.
Yes.
Accident, may read, Lordship.
Yes.
Accident took place near my house. Place of accident is the national highway. It is not a fact that there was no road divider while proceeding vehicle of the deceased. Vehicle of the deceased was proceeding ahead of my vehicle. There was fog and the vehicle was not speed. It is not a fact that I have deposed falsely. It is not a fact that I have not mentioned correct time of accident in my affidavit. It is not a fact that the driver of the truck had no fault. Lordship, may kindly see this line. It is not a fact that the driver of the vehicle had no fault. Police took my statement. It is not a fact that I have not seen the accident.
Wow.
This is this line, Lordship. It is not a fact that driver of the truck had no fault.
Even if we take it
Yes.
on its face value, it is his opinion only.
Yes. Just I wanted to show your Lordship.
Okay. This may be case of wrong recording.
Yes. Maybe, Lordship, I'm not saying, just I have pointed out.
Okay. Yes, Mr. Mandal. Anything else? Ms. Chaudhary,
Lordship,
you
I
have
may be allowed
anything?
to reply. This much only, Lordship, these 2 points are mainly
Okay.
very good. If I require to reply, I may be allowed to reply, Lordship.
Yes, Mr. Mandal.
Your lordship,
If you want-
first of all, so far the framing of issue is concerned,
Oh, yes.
there is no specific pleading of contributory negligence.
No, in their written statement, they have taken.
Not contributory negligence. They are saying sole negligence is of the car.
No
They have
contributory
never
negligence.
pleaded that there was contributory negligence.
It is there. You
I-
read their written statement.
I have WSO.
Lovely, ma'am.
Lordship, from the judgment, I'm saying.
No, you read from this record. I have flagged it. I have flagged the written statement
Contributed.
with blue flag.
No, judgment of likha.
With blue flag is there. First paragraph.
It is there. Your Lordship.
Yes, what is the submission?
Now, another important fact is that the owner and driver of the offending vehicle, they have filed their written statement,
Yes.
but they have not adduced any evidence regarding the allegation made by the claimants regarding the nation negligent driving.
Okay.
Now here, I will rely on judgment, your lordship, wherein there was finding of the Supreme Court not only is the owner come driver, not the authorization, interesting. If the owner come driver of a car was setting up a defense plea that the accident was result of not his, but the truck driver's carelessness or rashness, then the onus was upon him to step into the witness box and explain as to how the accident has taken place. The fact that such and such choose not to depose in support of what has been pleaded in his written statement further suggests that he was himself at fault. The High Court therefore ought not to have shifted the burden of proof. This is, your lordship, this is one aspect where in the judgment it is seen that they have filed written statement. OP 1, 2, and 3.
Yes.
I will refer it with my argument. Next. This is one aspect. Another aspect is that, your lordship, the police, after due investigation, has laid down charge sheet against the driver of the truck. And that much is sufficient for the tribunal to hold that the driver of the truck was at fault. For this particular aspect, your lordship, there is one appropriate judgment.
Mr. Mandal, you are not ready.
No, your lordship, I am ready. One particular judgment wherein our High Court have said there cannot be any presumption of 50-50 in case of head-on collision.
Presumption of?
50-50. The other side has to adduce some evidence to show that the other vehicle has also contributed. There is no such evidence.
Yes, no, in your case, there is evidence that the truck
I mean,
came to the wrong side.
wrong track.
Wrong side.
Wrong track. And to that to that point, there was no cross-examination. So
Yes.
it is admitted position. And so far charge sheet is concerned, your lordship, recently the Supreme Court also give one judgment where charge sheet is sufficient. Filing of charge sheet. Perhaps there is two judgment. One is recent judgment, your lordship, of 2025.
What it says?
The FIR having been lodged and the charge sheet has charge sheet files against the owner driver of the offending vehicle. We are of the opinion there could be no findings that the negligence was not established. This is 125. This one is also of 25. Supreme Court, your lordship. It is settled law that once charge sheet has been filed and the driver has been held negligent, no further evidence is required to prove that the bus was being negligently driven by the bus driver, even if the eyewitness was not examined. To that extent, the Supreme Court has said.
And suppose ultimately he is acquitted.
No, acquittal has no bearing. It is only confined to the charge sheet, not the findings of the court. The Supreme Court is very much specific and it is law laid down.
No, what has been laid down? Read.
It is settled in law that once a charge sheet has been filed and the driver has been held negligence,
Driver
no
has been
further
held.
evidence.
That means completion of trial.
No, once charge sheet said, no.
Charge
Once
sheet
has been filed.
And
The
driver
has been held negligent.
when he can be held negligent.
No, your lordship, this will not do. This one will do. The FIR having been lodged and the charge sheet filed against the owner driver of the offending vehicle, we are of the opinion that there could be no findings that negligence was not proved. This one, Your Lordship, this is recent.
No, why you are going for judgments? In your case, there is clear
Scientific
evidence.
evidence.
So you go for that instead of,
Your Lordship, that cross part is not available with me. So
but it
my
is
learned-
available with her. She has read it. It has not been contradicted.
Original I have given to your lordship and the photocopy I am
lordship.
having lordship.
You
My
take,
learned friend supply me one
Yes,
copy.
photocopy is there lordship.
no,
Original to sign. No question for them.
give it to her. No, it has not been contradicted.
Yes, Your Lordship.
Any other submission?
Your Lordship, the grounds that has been taken in the appeal, they have never disputed the authenticity of income tax return, or they have not disputed the income tax return filed by the claimant.
Okay.
It was never disputed. So they cannot dispute this. And so far business is concerned, Your Lordship, there is no specific cross-examination on that part. That even after Exhibit 4.1 of foresee income of the deceased was reducing. In business
Yes, Mr.
this
Goswami,
that the accident.
Mr. Mandal, do you have anything else?
Your Lordship, even my learned friend have submitted that the business is still there, but even the business is there, then also the claimants will be entitled for entire compensation. There is one judgment of Supreme Court also. It is R. K. Ramaya versus National Insurance Company.
What it says?
It says mere fact that the deceased share of ownership in the business ventures were transferred to the deceased minor children just before his death or to the dependents after his death is not sufficient justification to conclude that the benefits of this business continue to accrue to his dependents.
No, this is a different case. Here, it was transferred, but she has submitted income tax return showing earnings in the subsequent financial year. Some earnings, her submission is, this case would not cover.
House property need not be determined merely because the property has been distributed to the dependent. Another finding is that entire amount under income from house property and agricultural land, though this is business, need not be deducted merely because properties have been bequeathed to the dependents. Compensation toward loss of managerial skill can be awarded.
No, Mr. Mandal, here the document which Ms. Chaudhary is relying
Yes.
is not on record.
Yes, but it is not a part of the record.
Neither any application.
I have not exhibited. Now, apart from that, Your Lordship, whether Your Lordship can go to the extent of enhancing this compensation, because if Your Lordship,
There is no prayer.
there is no cross objection, but still the court can, if it feel appropriate. Why I am saying these are all law points, not on facts. If Your Lordship see that 30% future prospect has been granted. As per Pranay Shetty, it is self-employed, so it
No,
is
no,
40%.
Mr. Mandal. First you defend whatever you are getting, then you think about enhancement. Her submission is that you are not entitled to compensation to the extent what has been granted to you by the
No, Your Lordship, so far the income of the deceased is concerned, I have proved the income without any dispute that has been admitted. So far the income tax return is concerned.
Okay.
And there are lots of judgments of this court that the proof of income tax return is not required.
But you have not produced any judgment today.
Your Lordship, I have one chart, Your Lordship. Your Lordship.
You give that chart to me later on.
Yes, Your Lordship.
Yes, Mr.
It's
Goswami.
all reported, Your Lordship.
You give a small gist of your submission.
Yes, your lord.
Yes, Mr. Goswami, do you have anything?
Yes, Doctor, I have a small submission.
That's it. The issue whether there is contributory negligence or not is a matter of argument between my learned brothers and sisters. My position is that
You are the insurer of the car.
I'm an insurer of the car. That's it. The legal principle here in this case is if a person is guilty of say, or he's if he has contributed to the accident, then he is not entitled to compensation. To the extent he is
To the extent of his contribution.
So there are judgments of three. I have a lordship rely on three judgments of the Supreme Court. Very clear that the employer shall not be held liable for to that extent of contributing negligence. Employer in turn, that means even insurer is not liable for that person.
No, employer insurance, insurer.
No, lordship. Insurer can be liable, lordship. I'll submit. Insurer can be liable only when the liability is marked on the
Owner.
So if the owner is, lordship, in all these cases, lordship, I'll say, if the owner has been, lordship, not held, not liable for compensation, if the driver, he has contributed to the accident, even the owner of the vehicle is not liable to the accident.
And in this case, owner was not found.
Yes, lordship. In this case, even if there is contributing negligence, owner is not liable. There may not be any contribution. There are two aspects of it. Either my learned friend succeeds in holding that there is some contributing negligence, or my learned friend says that there is no contributing negligence. In both the events, lordship, the insurance company is not liable of the particular vehicle of which vehicle he was driving. In both the events, even if there's no contributing negligence, there is no question of my paying it. Even if there is some contributing negligence, insurance company is not liable to pay that much of, because the owner himself is not liable. To that extent, also, I may be allowed to submit this to the paras, lordship. Very clearly, it is that this is
Okay.
I'll read out.
Do you mark the paragraph?
I marked the paragraph. Paras 18, 19, 22 of one decision, para 18, 11, and para 9.
Okay.
There are various other judgments, but these three also are more popular.
Any reply?
In this regard, lordship, I just want to make one point that lordship, this pleadings, lordship, now it is made, lordship. Now, these things, this statement are not in the record, lordship. Whether the owner is, they are not liable to indemnify the owner, or they have not made any contribution towards the accidents. These statements are not in the record, lordship. This is not available in the record. Now, at the appellate stage, lordship, these statements are coming, lordship. But they have not appeared, they have not filed any written statement, they have not stated their plea before the learned tribunal, so that the learned tribunal came to a proper findings, lordship.
Okay.
The learned tribunal did not make any issues on that, lordship.
Heard.
And lordship, one more point, lordship, regarding search sheet, lordship. Regarding search sheet, I want to place one judgment, lordship. So now, this lordship, where is a final report is given, our high court, lordship.
In this case, charge sheet has been exhibited.
Lordship, here also in this case, lordship, this is.
No, in the
disposed of
present
on-
case.
Lordship,
In the present case, whether
Yes.
charge sheet has been exhibited.
search sheet has been exhibited.
Okay.
On that point, I am saying, because
Yes.
learned friend has said, it is disposed of on 24/8/2022 by our High Court, lordship. Here, lordship, final report has been submitted. Final report has been submitted stating that there was no Russian negligence driving of the driver of the truck. In spite of that, lordship, the truck was made negligence or offending vehicle. Whereas FR says that there was no negligence driving of the truck. It was the car who hit the truck, backside of the truck.
Yes, there must be other evidence.
Yes.
There must be some other evidence.
Evidence means eyewitness, lordship. That was not considered. That is why they have stated that this FR cannot be accepted. This is the judgment of our High Court, lordship.
No, but the facts may be different.
Your lordship.
Same lordship, final report.
I am also relying
Final
on
report.
judgment of this honorable court.
No, you give your judgments not in this way.
Okay.
My-
Judgments which you are relying,
Yes, your
give a
lordship.
brief
Yes, lordship.
note.
Yes.
Heard Miss M. Chaudhary,
They took it.
learned counsel for the appellant. Also heard Mr. D. Mondol, learned.
Lordship, may I crave indulgence of your lordship? One more judgment, lordship, of our high court regarding regarding income tax. Lordship, if it is not proved the precise income, lordship, in this case, lordship, it was remitted back to the learned member to examine to that aspect of the matter only income tax part, lordship. This is the judgment of our high court. It was disposed of on lordship.
Grounds are- there is no
For
such
11/25,
ground.
lordship. May I hand over lordship, please?
Yes. Also heard Mr. D. Mondol, learned counsel for the
Ito Dilu.
respondent number 124 slash claimants, as well as Mr. R. Goswami, learned counsel for respondent number 7. This appeal under section 173 of Motor Vehicles Act 1988 has been filed by the appellant Messrs. New India Assurance Company Limited, impugning the judgment and award dated 15/5/2013 passed by the Motor Accident Claims Tribunal number 2, Kamrup at Gauhati in MSC case number 208/2009. Stop. By the aforesaid judgment, the present appellant was directed to pay a compensation amount of rupees 65,46,000 along with an interest at the rate of, what was the interest?
6%, lordship.
6%
50% we have already
per
deposited,
annum.
lordship.
6% per annum from the date of filing of the claim petition till the date of judgment, till the date of realization. Stop. Next para. The facts relevant for consideration of the instant appeal, in brief, are that the present respondent number 1 to 4 as claimants have approached the Motor Accident Claims Tribunal number 2, Kamrup Metro, Kamrup at Gauhati, by filing an application under section 166 of the Motor Vehicles Act, claiming compensation of rupees 1 crore from the appellant insurance company on account of death of their husband / father / son, Rajesh Datta, in a motor vehicular accident. Stop. It is contended by the claimants in their application under section 166 of the MV Act, before the Motor Accident Claims Tribunal, that on 29/11/2008, when the deceased Rajesh Datta was proceeding from Dibrugarh to his residence in a Maruti vehicle bearing registration number AS01AD 5077, and when he arrived near Sialkati Tea Estate, one truck bearing registration number AS23E 1694, which was proceeding from opposite direction in a rash and negligent manner, knocked the said vehicle. As a result, knocked the Maruti vehicle, as a result of which Rajesh Datta sustained grievous injuries and died on the spot. Stop. It is also contended in the application filed by the claimants before the Motor Accident Claims Tribunal that after the accident, a police case an FIR was lodged, on the basis of which Sabua PS case number 158/2008 was registered under section 279/304/427 of the Indian Penal Code. Stop. The opposite party number 1 and 2, as well as the present appellant as opposite party number 3, filed written statement against the claim of the claimants. On the basis of pleadings, next para, on the basis of the pleadings of the parties, following issues were framed by the Motor Accident Claims Tribunal, number 2, Kamrup. Quote from A at page 8, from page 8, quote A. During the inquiry, the claimant side examined 2 witnesses who were also cross-examined by the opposite parties. The opposite party, that is the present appellant, adduced no evidence countering the claim of the claimants. Stop. Ultimately, by the judgment and award which has been impugned in this appeal, the Motor Accident Claims Tribunal had come to affirmative findings as regards both the issues which were framed by it and directed the present appellant to pay the compensation in the manner which has already been described in the foregoing paragraphs of this judgment. Stop. Ms. M. Chaudhary, learned counsel for the appellant, has submitted that the Motor Accident Claims Tribunal, Kamrup, number 2, Kamrup, had erred in directing the present appellant to pay the compensation amount, to pay the entire compensation amount. She submits that in the written statement filed by the present appellant before the Claims Tribunal, Motor Accident Claims Tribunal, a specific plea was taken that the accident was caused by head-on collision of the truck as well as head-on collision between two vehicles, that is the truck as well as the vehicle in which the deceased was there, that is the Maruti vehicle. She submits that though the insurance company has taken specific plea regarding contributory negligence by the driver of the Maruti vehicle also. However,
That disease himself was the driver.
by the driver of the Maruti vehicle, within bracket, the deceased himself. However, the Motor Accident Claims Tribunal did not frame any issue to that essay in that regard and have not considered the aspect of contributory negligence committed by the deceased, which resulted in the accident. Stop. She further submits that the Motor Accident Claims Tribunal also erred in coming to the conclusion, in relying on the testimony of the eyewitness, that is CW2. She submits that during cross-examination, the CW2 has categorically stated that the vehicle in which he was traveling was moving behind the vehicle in which the deceased was traveling, and it was a foggy night. She submits that the visibility during the foggy night may not be clear, and this aspect was not considered by the tribunal while coming to the conclusion. She has further submitted that the Motor Accident Claims Tribunal has not discussed anything regarding the aspect of contributory negligence by the deceased himself, or regarding the liability of the opposite party number 4, that is the present respondent number 7, to share the portion of the compensation which was directed to be paid to the claimants, proportion to the negligence, contributory negligence of the deceased. She further submits that in the accident information report as well as in the FIR, it was clearly stated that both the vehicles were involved in the accident and it occurred due to head-on collision between two vehicles. But this aspect was not taken into consideration by the Motor Accident Claims Tribunal. She further submits that as regards assessment of the income of the deceased, the Motor Accident Claims Tribunal also erred in concluding that the annual income of the deceased was rupees 3,34,980. She submits that the income tax return for the year 2008-2009, on the basis of which the earning of the deceased was assessed by the tribunal, was not proved in accordance with law by examining the authorities who have issued the said income tax return. Stop. What else?
This annual income is accepted as lordship 502,470.
Now, ultimately,
After one.
after deduction.
After one third deduction, it came to 334,980.
Okay.
After deducting, it is come.
Learned counsel for the appellant has cited following rulings in support of her submissions. 1, 2, 3, 4. You give a list.
Lordship.
Stop. No, before that, aru eta paragraph. Learned counsel for the appellant has further submitted that the income tax return submitted by the wife of the deceased after the death of Rajesh Datta for the year 2009 and 2010 shows that the business of the deceased is still giving some income, and therefore the extent of dependency may not be as assessed. Extent of loss of earning of the claimants may not be as assessed by the Motor Accident Claims Tribunal. She submits that she may be granted leave to file an additional affidavit to bring on record. She orally submits that the insurance company may be allowed to file the additional affidavit, file an additional affidavit, file an
Additional evidence.
sorry.
Additional evidence.
Additional evidence.
This is oral submission.
Yes.
Additional evidence in appellate stage.
Order 41.
The order 41 rule 27 to bring on record the said document. However, no. Stop. These. On the other hand, learned Mr. D. Mondal, learned counsel for the claimants, has submitted that the tribunal has correctly assessed the negligence for the accident.
Lordship, so far issue is concerned, my submission will be recorded. Issue number 2 covers that aspect of contributory negligence.
Okay.
Because
Rightly assess the negligence of the driver of the truck as the cause for the accident in which the deceased Rajesh Datta died. He submits that the tribunal, while considering the issue number 2 framed by it, has categorically come to the finding that it was the driver of the truck who was responsible for the accident which resulted in death of this death of Rajesh Datta. He further submits that the evidence of independent eyewitness, that is CW2, categorically clearly indicates that the offending vehicle hit the Maruti car from the front side after coming on the wrong side of the road, which indicates that it was the driver of the truck who was negligent in driving the said truck, which resulted in the said accident. So he further submits that in the grounds taken by the appellant in the memo of appeal, the no such ground has been taken that the tribunal was wrong in relying on the income tax return in assessing the income of the claimant, income of the deceased. Stop. He further submits that the insurance company also did not adduce any evidence before the tribunal during the inquiry to counter the case of the claimant, and therefore he submits that the tribunal has correctly arrived at the finding. He, however, submits that the compensation awarded to the claimants is on the lower side, considering the fact that the tribunal has against the component, which component?
Your lordship, future prospect.
Future prospect.
As well as multiplier also. The
Has-
disease will fall within the age group of 31 to 35.
Has against future prospect
Future prospect will be 40%. Court has taken 30%.
has taken 40%, has taken 30% of the income of the deceased, whereas it ought to have been
40%.
40%. As per
Pranay Shetty's judgment.
as per the judgment of the apex court in the case of Pranay Shetty versus citation there. He has cited following rulings in support of his submission. Give this.
And multiplier also, your lordship.
He also submits that considering the age of the deceased at the time of his death, that is,
The
what
age
was
of
the
the
age?
deceased was 35 years plus something.
35 years, 8 months.
So till he does not complete 35, he will fall within the age group of 31 to 35. And the multiplier will be, I think it is 16.
क्या लिखा?
16. no?
Last line.
He also submits.
He also submits that considering the fact that the deceased was more than 35 years of age at the time of his death,
But has not completed 36. So will
But-
not fall in the 36 group.
but has not completed the age of 36, Hence, the multiplier in computing the compensation ought to have been 16 in place of 15. Stop. On the Mr. R. Goswami, learned counsel for respondent number 7, has submitted that since the tribunal has categorically given a finding that it was the driver of the truck, offending truck, who was at fault, and because of which the accident occurred, the respondent number 7, which is the insurer of the Maruti vehicle in which deceased was traveling, is not liable to share the compensation to be paid to the claimants. He further submits that even if, yes, Mr. Goswami, what was your submission? Even if the owner of the Maruti vehicle was found to have contributed to the cause of accident, the insurance company is not liable to indemnify the owner.
Because of the underlying principle that a person is not liable for compensation to the extent of his contribution for causing the accident. That is the underlying principle.
In support of his submission, he has cited the ruling of following rulings. Number 1, Usha Rajkwa.
No, not that. One is Rajlal.
Lordship, Usha Raskwa is for contributory negligence.
No, sorry.
One is Rajani, there is Tio Anthony, and there is another.
Number 1, Raj Rani and others versus Oriental Insurance Company Limited, reported in 2009 13 HCC 645. T.O. Anthony versus Caravan and others, reported in 2002 SCC Criminal 738.
And there is not.
Number 3, Messrs. Tamil Nadu State Transport Corporation, ye darja band karo. Tamil Nadu State Corporation versus Natarajan and others, reported in 2003 6 SCC 137. Stop. I have considered the submissions made by learned counsel for both the sides and have gone through the materials available on
Just
record.
add one line. Lordship. In any case, Lordship, the owner of the vehicle is not a third party as far as the insurance is concerned.
Yes.
Owner of the vehicle is not a third party, so far as the insurance.
Actually, your lordship, the insurer of the vehicle has been improperly joined as defendant. They cannot be joined as defendant when the owner is not available.
He also submits that owner of the vehicle of the
Car.
Maruti car cannot be regarded as a third party as regards the insurer of the said vehicle. Hence also the insurer of the Maruti car is not liable to pay any compensation. Naam likhi, hearing concluded, judgment reserved. You give a list.
I just wanted to this point, Lordship, now raised by my learned.
Which point?
Lordship, this regarding owner is not responsible, it's not a third party.
You give in your short note.
Lordship, Lordship.
I will take into
And
consideration.
regarding, enhancement also, this is at that time, it's a case of 2009 Lordship, and it's a case of 2013, judgment was of 2013. And my learned friend has relied on 2017 for multiplier and all Lordship, multiply wrong.
Okay, whatever you want to add, you can,
Yes, Lordship.
I will make necessary changes.
Obliged, highly obliged.
Lordship, regarding this additional evidence, Lordship, may I file a short petition for that?
No,
Lordship?
that is during,
They
that
have
I
not
will,
made any objection.
I will not say anything, but
Lordship, I will file a- for accepting only leave granted, Lordship, and grant me leave. By tomorrow, I'll file it.
I will discuss this in my judgment.
Lordship. And that judgment that I have given, Lordship, the original evidence is there, Lordship. Lordship. That may kept in the report. Lordship.
Hearing concluded, judgment reserved.
Obliged.
Must oblige. Must oblige, Lordship.
Yes. Yes, Mr.
Lordship,
Bhattu.
in this case, we have challenged the quantum of variance.
Quantum,
In this case, Lordship, our main count is that, future prospect should be 40%, but the learned member considered it as 50%. Since this was a contextual employee. Lordship. And second thing is that under the head of loss of life and care to the claimants, it was awarded to the 1,40,000. 1,40,000. Let's say as per the promissory judgment, let's say under the head of conventional, it should be granted 70,000. Loss of estate 15,000, funeral expenses 15,000, and for the loss of consortium 40,000. So if we reassess the calculation after considering a 40% future prospect, then what's it? Total compensation, including conventional head, comes to rupees 15,38,000 instead of rupees 17,05,000. That's it.
you have calculated it in a
Yes, yes.
different sheet.
He has calculated. I have also calculated. Let him finish my notes.
Photocopy হব,
এইটো দি দিলো,
photocopy কৰিব পাৰিব,
এইটো দি দিওকচোন।
ইয়াত নাই, আজি কৰিব install. You, Mr. Bhattu, you have a copy of this,
No,
You
they
don't.
copy them. So I have my own copy. I have given.
but your calculation would be different from his calculation.
But your lordship will decide that. It is not his appeal. I'm not, may not agree with.
No, I am not taking your case now. I am taking up his. I'll come to you after he concludes.
Yes, yes, yes. Lordship, in this case, Lordship will find, in my memo, will page number 11.
Yes. Your only grievance is
Grievance is
regarding quantum.
Quantum, Lordship, instead of 50% future prospect, it should be 40%. And under the conventional head, it should be 70,000 instead of rupees 1,75,000. Learned member considered the monthly income of the deceased as rupees 10,000 Accordingly, annual income for this is come up rupees 1,20,000. If we add 40% PCR prospect, then it comes to rupees 1,68,000. After 50% deduction, and by applying appropriate multiplier, comes to rupees 14,28,000. And if we consider loss of estate 15,000, funeral expenses 15,000, and for illegal consortium for the mother and father, rupees 40,000, then it come to rupees total compensation come to rupees 15,38,000. But the learned member considered it is 17,05,000. Only my limited ground is that's it.
Why the future prospect has been wrongly assessed? Why? Why you are saying that it is wrong?
As per the lordship pronunciation case, if he is a government salary holder, then it is different consideration. But he is a permanent employee. He is not a permanent employee. He is just a temporary employee.
Read that portion of pronunciation.
Lordship. So since it was proved that he was a temporary employee and his income was not proposed, the learned tribunal considered is rupees 10,000. So it is not his appeal, lordship. It is my appeal. So instead of lordship future prospect 50%, it should be 40%. Multiplier will be sent.
Okay.
Only limited conditions. So future prospect and under the convention method.
Any judgment you are relying?
Prononcity case, lordship.
Pronunciation.
Prononcity.
You have a copy of that?
Yes.
Which para you are relying? Which para you are relying?
61. In case of the deceased was a self-employed or on a fixed salary, an addition to 40% of the established income should be one where the deceased was below the age of 40 years. An addition of 20% where the deceased between the age of 40 to 50 years. And 10% where the deceased is between 50 to 60 years should be regarded as the necessary method of computation. The established income means the income minus the tax contribution.
You take it back. Para?
Para 61. 61. Loss 4.
In this case, the deceased was self-employed.
What said you going to lots of temporary employee? Lots. Contextual employment. He was under contextual employment.
He is in the corporate company. He is a BTech in the company. Private company.
Okay. What is your submission?
My submission is only, my lord, as per the calculation, my lord. In the judgment, the court himself admitted that his income is 11,872. Your lordship will come to the page 11, my lord, of the judgment. The lordship, but the opposite party has not disputed that he is earning a net monthly salary of 11,872. Though from the record, it seems that he has contractual employment at the relevant time, being the BTech, it can be safely presumed that he would have been employed or would have been self-employed even if his service were not renewed by the
employee at the company. Though he is not a straight jacket formal to assess that, it would have been his salary as such. The event assessment is 10,000. I fail to understand that aspect, my lord. It is only on presumption that he may not be in the service. That is why it will be 10,000. Maybe he continue till his retirement, my lord. So that part is I am aggrieved, my lord. That is why I have given the calculation by taking into 11,872, which is court has also admitted.
You have not filed any cross objection.
My lord, it's not necessary, my lord, because our high court decision is there that in appeal, it is an enhancement. When it comes for the appeal, it is a continuation. And it can be for the end of justice, the court can give it. I will give it to judgment. Our Honorable BP Court's judgment is there. Even recently in Kitabjan BB also, Robin Justice Pukan has also said that.
And what is your response to his submission that the future prospect?
My lord, future prospect is okay, my lord, as well as Pranay Shetty. But Pranay Shetty has also given in the last page, your lord, you will see the judgment. That is in the 61 paragraphs, subclause 8, my lord.
Yes.
That reasonable figure on the conventional head, namely the loss of estate, loss of conservatorium and funeral expense should be 15, 40 and 15 respectively. Therefore, said amount should be enhanced at the rate of 10% every 3 years. That is not calculated, my lord. I have calculated and I have given this. Every 3 years. It is Kitabjan BB Court. Is it judgment?
Anything? Anything you want to?
Yes, I will rely on this judgment. Regarding the, my submission, if there is no cross appeal, they appeal by the insurance company. The amount cannot be enhanced as per the appeal court decision also. No. When there is no cross appeal also. No, my lord. I can produce that judgment also. No, my lord, learned friend is late. My lord, here is the judgment. That is our High Court in 2013, 5 GLT. I am giving the copy, my lord. Respondent number 1 and 2. And recently, my lord, in MSc appeal, Supreme Court judgment also. Supreme Court judgment is at the site.
When will you produce that?
Yes, yes.
Okay.
Yes.
Heard
This is to judgment.
Heard Mr. K.K. Bhatto,
And the calculation I have given, my
learned counsel for the appellant. Also heard Mr. K. Bhattacharjee, learned counsel for respondents / claimant. Anybody else is appearing?
No.
This appeal under section 173 of Motor Vehicles Act 1988 has been filed by the Reliance General Insurance Company Limited, impugning the judgment and award dated 16/2/2015 passed by the Motor Accident Claims Tribunal cum Additional District Judge within bracket FTC number 3 Kamrup Metro in MEC case number 72 in MEC case number 362/2011, whereby the appellant insurance company has been directed to pay a compensation amount of rupees 17,05,000 along with an interest at the rate of 6% per annum from the date of filing till realization. Stop. The facts relevant for consideration of the instant appeal, in brief, are that that the present respondent claimant approached the Motor Accident Claims Tribunal, come Additional District Judge, FTC number 3, Kamrup Metro, by filing an application under Section 166 of the Motor Vehicles Act 1988, praying for compensation on the account of death of their son in a motor vehicular accident on 7/12/2010 involving a Scorpio bearing registration number AS01AM 2917. Stop. The present appellant contested the claim of the claimants by filing written statement. Stop. On the basis of pleadings of the parties, the Motor Accident Claims Tribunal framed following issues. Quote A from page 8 and page 9. 8 from page A and B from page 9. Stop. In support of their claim, the claimants adduced evidence of 4 witnesses during the inquiry before the Motor Accident Claims Tribunal, whereas the present appellant adduced evidence of 1 witness. Stop. Ultimately, after completion of the inquiry, the Motor Accident Claims Tribunal passed the impugned judgment and award, whereby the appellant was directed to pay compensation to the claimants in the manner as already discussed in the foregoing paragraphs. Stop. Mr. K.K. Bhatta, sorry, Mr. K. Bhatta, learned. Only 1 K?
KK Bhattu. He is KK Bhatta, I am K Bhatta.
Yes, I am referring to him only. Mr. K.K. Bhatta, learned counsel for the insurance company, has submitted that the insurance company has filed this appeal on being aggrieved only with the quantum of compensation assessed by the Motor Accident Claims Tribunal. He submits that the Motor Accident Claims Tribunal erred on 2 counts on assessing the in computing the quantum of the compensation which was directed to be paid to the claimants. He submits that the deceased was only doing a contractual job, that is, he was not having any permanent job at the time of his death. Hence, against the loss of future earning, against the component of loss of future earning, addition of 40% of the annual income of the deceased should have been made in terms of the decision of the apex court in the case of National Insurance Company Limited versus Pranay Sethi and others, reported in SCC citation you have
Yes, but
reported in
2017, Pranay Sethi, my lord, 2017-16 SSC 680.
2017-16 SCC 680.
680.
680. He submits that, however, the tribunal has erroneously added 50% on account of 50% of the earning of the deceased on account of loss of future prospects. He further submits that the tribunal was also wrong in assessing an amount of rupees 1,40,000 on account of loss of love and care to the claimants. He submits that as per the decision of the apex court in the case of Pranay Sethi, within bracket Supra, the loss of estate, the amount, loss of estate, the amount of 15,000 ought to have been computed against loss of against the component loss of estate, whereas against the funeral expenses an amount of 15,000 should have been computed, and against the amount of loss of consortium, loss of filial consortium, an amount of 80,000. Ought to have been computed. He submits that the compensation computed by the Motor Accident Claims Tribunal was wrong, and it ought to have computed in the following manner. Dash D, I will dictate it. On the other hand, Mr. K. Bhattacharjee, learned counsel for the claimants has submitted that the tribunal had heard in assessing the income of the annual income of the deceased on lower side at rupees 10,000 per month, when there was clear uncontroverted evidence on record which which suggests that the net monthly income of the deceased at the time of his death was 11,872. He submits that in the view of aforesaid facts, the compensation awarded to the claimants may be reassessed and may be enhanced, though there is no cross objection filed by the claimants. He submits that even if in a case the claimants does not file any cross objection and the court in appeal, while considering the appeal, comes to the finding that the compensation was wrongly computed on a lower side, it has power to enhance the compensation. And in support of his submission, he has cited following rulings 1, 2, 3. You give the citations.
I've given that, my lord. One is, my lord, 2013 5 GLT, page 461. I've given them. Repeat it here. Only two judgments I have submitted, my lord.
Number 1, Oriental Insurance Company Limited
Versus Mulan Hazard.
versus Musammat Kitabjan Bibi and others, within bracket, MAC appeal, within bracket, judgment dated 13/10/2025, dated 13/10/2025, in MAC appeal number 347/2017. Number 2, Oriental Insurance Company Limited versus Mulan Hajorika and others, reported in 2013 5 GLT 461. He has submitted that the compensation ought to have been assessed in following manner. Dash. ये तो पिसत थोड़ा.
My lord, may I, my lord, so far the interest part is concerned 6%. It is a settled law, then 9% should be given. It is by in the Kitabjan Bibi as well in the Supreme Court also, my lord, in pronounce it, 9%.
Why have you not filed cross objection?
My lord, it is not, my lord, here. Your lordship will go to the paragraph 15 of the.
Learned counsel for the
15, paragraph 15.
claimants
State, my lord.
has also filed that the Motor Accident Claims Tribunal has also granted interest at a lower rate of 6% per annum on the awarded amount, whereas as per the various rulings of the apex court as well as of this court, the interest should be awarded at the rate of minimum 9% per annum. Stop. ওপৰত, while in the submission of learned counsel for the appellant, learned counsel for the appellant has also submitted that when there is no cross objection filed by the claimant, the awarded amount cannot be enhanced by the court in appeal. And in support of his submission, he has cited which ruling. You will give ruling tomorrow.
Tomorrow I shall.
Stop. I have considered the submissions made by learned counsel for both sides and have gone through the materials available on record. Heard both sides. Hearing concluded, judgment reserved. You give that citation by within 2 2 days, 2-3 days. Tomorrow it will be good if you. You take back this Pranay Sethi.
Item 16.
May I please give me the. Lordship, this hopefully prepared by the claimant, Lordship, for enhancement of compensation, mainly quantum, Lordship. And here, Lordship, this income certificate was exhibit 3, Lordship, Gauhati certificate. So that was not taken into account, and income is only assessed as 4,000 monthly, Lordship.
How much Gambura certificate mentions? What was the income stated in the Gambura certificate?
He was having business.
So what was the income?
Income was 8,000.
Why the tribunal did not consider the Gambura certificate? What was the reasoning?
Gangura was not examined.
Mm.
But certificate is there.
Where is that relevant para in the?
Hmm? 21. Now coming page number 5 of the judgment, Lordship, 21 para. Now coming to the question of income of the deceased, the claimant in her evidence stated that the deceased was a businessman by profession and his monthly income was 8,000. The claimants have produced one certificate of exhibit 3 issued by the Gambura, wherein it was shown that the monthly income of the deceased was 8,000. But the claimants have not proved the said certificate by calling the issuing authority. Hence, this same is not considered as evidence. In absence of positive evidence in regard to the income, the notional income of rupee 4,000 is taken as rising out of the loss of assessing the loss of dependency, Lordship. And regarding this, Lordship, there are so many rulings, Lordship, that the notional income Said Sadiq judgment, Lordship knows that on the Supreme Court he said Said Sadiq, Lordship, that citation.
Where is the judgment?
There, I'll give the citation, Lordship, I'll give the full judgment also.
Which para you are relying?
No, that judgment I am referring, Lordship. That I'll give, Lordship, but.
No, Mr. Agarwal,
Yes,
you
Lordship.
come prepared. Come prepared.
The other judgment is also there, Lordship.
You are relying on a judgment which you don't have.
Yes, Lordship.
And the judgments which you are not citing.
Yes, Lordship. Supreme Court also saying, Lordship.
No, don't give it to me directly. First, you make submission
Yes,
on why you are relying
Yes,
the
Lordship.
citing that judgment.
The Honorable Supreme Court is said in Dhaneshwar Biswal versus DM and managers and another that whether High Court monthly income is assessed at 8,400, tribunal treated the injured as a laborer and assessing the monthly income of rupees 8,400 by taking the daily wages of 280. No reason found in interference with the same impugned judgment of the High Court is set aside, award is restored, appeal disposed of. Whether documentary evidence is even not required, for minimum wages can be taken, Lordship.
No, what should be the criteria for assessing notional income?
Lordship, that is minimum wages act that will prevail. Lordship. That time, Lordship.
Where is that? And what was the minimum wages at that point of time?
Nearly, Lordship, 7,500, like that only, Lordship.
What was the minimum wages at that point of time, as per Minimum Wages Act? Where are the materials before the tribunal?
No, Lordship, tribunal material is that exhibit, Lordship. That by the business, he was earning 8,000. And for businessman is a skilled worker, Lordship. But that has not been discussed, Lordship. So straightway, though some proof is there regarding the income 8,000, Lordship, it was taken as 4,000 only.
Okay.
And Lordship, another thing now that has come, Lordship, fairly speaking, Lordship, that at that time, Lordship, the future prospect was 50%, Lordship. Future prospect was 50%, that has been granted, but according to new law, MBA Lordship, I am entitled for 40% only, Lordship.
No, Mr. Agarwal,
Yes, Lordship.
if you want to make some submission, you have to make it in a way so that I understand it.
Yes, Lordship.
You have to be audible.
Yes, Lordship. Now I am fairly speaking, Lordship, that a pronounce judgment. Now I am entitled for 40% as future proceedings from my income, Lordship. That is 8,000, Lordship. So that income will be higher, Lordship, and my future profit will be lower. If we take the recent decisions of pronounce, Lordship. But MSCT has given 50%, Lordship.
So that should be lowered.
That should be lower, Lordship. My incomes, I'm fairly speaking, Lordship, but I don't know what my learned will speak. But that is my, and there are some rulings also that whatever is awarded, Lordship, in respect of 50% over this consortium head, etc., that cannot be reduced, Lordship. Recently, some ruling has also.
So what is your submission? You are making contradictory submission.
No, Lordship, what is coming, Lordship, development, that is, I'm also only submitting, Lordship. And my point is this income should be enhanced. 8,000, my income is there.
Okay, yes, Mr. Datta. Anything else?
And Lordship, this deduction is 1/4, that is correct, Lordship. And this consortium head, Lordship, earlier it was that love and affection, it was 1 lakh, Lordship. That is up to your Lordship. Now it is reduced to 40%, and after 3 years, it is enhanced by 10%, Lordship, 10% and 20% like that only. So this 1 lakh, that should be come from the insurance company, Lordship, though I am fairly speaking, Lordship, but it is the development of the law, Lordship.
Yes, Mr. Datta.
I have submitted, Lordship. Yeah. And interest should be 9%, Lordship, that is given 6%, Lordship.
Made, please, your lordship.
Just a minute, let me go through memo.
Your lordship, first of all, Gaubura is not authorized by law to certify such certificates, income certificates, that is. And also the Gaubura was not examined to prove that certificate. So, and also your lordship, 4,000 was taken as notional income. And
4,000 was less than the Minimum wages,
But
which,
minimum wages was considered, your lordship, since my learned friend, the claimants could not prove the fact that he was a businessman, whether he was skilled or unskilled or semi-skilled. So 4,000 was the notional income at that point of time. The accident occurred in the year 2012, your lordship. At that point of time, 4,000 was the notional income for unskilled labor. Now, your lordship, coming to the next point, 50% of the income was 50% addition was considered for future prospect. So my learned friend has already argued for me.
For
It should
lowering
be
it.
40%. So he has already accepted that fact. So I won't make that. I won't advance. Now there were 5 dependents, your lordship. So 1/4 deduction was considered. And as per Sarla Verma case, your lordship, 1/4 is the accurate one. 1/4 deduction. Now coming to the conventional heads, your lordship. It is in page number 15 of the memo of appeal, paragraph number 25. May I read, your lordship?
yes.
In addition to the aforesaid amount of
There are,
rupees
20?
25, your lordship. May I read, your lordship?
Yes.
In addition to the aforesaid amount of rupees 8,10,000, placing reliance on Rajesh and others supra, the claimants are also entitled to receive an amount of rupees 25,000 towards funeral expenses, an amount of rupees 1 lakh towards loss of consortium. Rupees 1 lakh is awarded towards the loss of estate, and another amount of rupees 1 lakh is awarded towards loss of care and guidance for minor. In total, the claimants are entitled to receive rupees 11 lakh 35,000 as compensation. Your lordship, those conventional hits as per the Pranay Shetty decision. Your lordship, I have only one copy. First, I will read and I will place it before your lordship.
Yes.
May I read, your lordship?
You mark the para which you are.
Your lordship, I have marked it already.
Okay.
On grant of loss of state, loss of consortium and schedule to the act. The said schedule has been found to be defective. The conventional and traditional heads, needless to say, cannot be determined on percentage basis because that would not be an acceptable criterion. Unlike determination of income, the said heads have to be quantified. Any quantification must have a reasonable foundation. There can be no dispute over the fact that price index, fall in bank interest, escalation of rates in many a field have to be noticed. The court cannot remain oblivious to the same. There has been a thumb rule in this aspect. Otherwise, there will be extreme difficulty in determination of the same, and unless the thumb rule is applied, there will be immense verification lacking any kind of consistency, as a consequence of which the orders passed by the tribunals and courts are likely to be unguided. Therefore, we think it seemly to fix reasonable sums, reasonable figures on conventional heads, namely loss of state, loss of consortium, and funeral expenses should be rupees 15,000, rupees 40,000, and rupees 15,000 respectively. The principle of revisiting the said heads is an acceptable principle, but the revisit should not be fact centric or quantum centric. It would be condign that the amount quantified should be enhanced on percentage basis in every 3 years, and the enhancement should be at the rate of 10% in a span of 3 years. Reasonable figures on conventional heads, namely loss of state, loss of consortium, and funeral expenses, should be rupees 15,000, rupees 40,000, and rupees 15,000 respectively. The aforesaid amounts should be enhanced at the rate of 10% in every 3 years. Your Lordship, now the next paragraph. Your Lordship, I will only read the relevant part. That is regarding the future prospect. Is it necessary, Your Lordship, because he's already accepted 40% addition? Now I will hand it over to Your Lordship.
Getting, looks at my income, the
Good. Easier than you. But Mr. A.R. Agarwala, learned counsel for the appellant. Also heard Mr. S. Datta, learned counsel for the respondent insurance company. Hearing concluded, judgment reserved.
can give the release
Yes.
tomorrow, by tomorrow.
Okay.
Interview.
Your Lordship, only one point. Otherwise, there were 5 dependents. Those 5 dependents, each they will get consortium, 40,000 into 5. In place, in
Plus
place,
20% enhancement, Lordship.
20.
Yes, 10% of the 3 years, Lordship, each. And this is Upar tragedy victim, Lordship, 9% interest.
But instead of those 1 lakh rupees,
Yes.
towards
But
loss of
I have
cons-
already told, Lordship. I have already explained.
Along with your judgments which you are relying,
Yes, Lordship.
you give a sheet of paper
Okay, Lordship.
on which give a brief summary of your arguments.
Okay, Lordship.
Your Lordship, that paragraph 25 will completely get modified. Because they won't be entitled to this.
Yes,
heads.
Lordship, I do admit, Lordship, I have
It
fairly
is,
submitted, Lordship. The position.
No, that he has already admitted.
Fairly submitted, I have fairly submitted.
We have to recompute.
That will get replaced by this new consortium rule.
Okay.
40,000
I
into
was
5.
new law, as per new law, also I have calculated, Lordship. I'll give the fair copy, Lordship.
Okay. Okay.
Day after tomorrow, Lordship will give, Lordship. Along with the reference, Lordship. 17.
Seven- 17 along with 18. 18 on order junel loise. This will remain tagged with 18. 18 on lower tag.
Item 19.
My lord, please.
Lordship, my senior is in legs, Lordship.
So what is the prayer?
She is on her way. Actually, the other court is passing the order, Lordship. So it will not take much time. Otherwise, she is ready, Lordship.
We'll take some other matter. We don't have much time.
Yes, my lord. We take some time.
It will take some time,
It
na?
will take some time.
Okay, heard Mr. S.P. Sharma, learned counsel for the appellant. Also heard Mr. R. Day.
AB day, my lord.
Sorry, A.B. Day, learned counsel for the
Respondent number 1.
respondent number 1. Learned counsel for the appellant has submitted that the conducting counsel for the appellant is on legs in some other court, and therefore an accommodation has been sought for. The prayer is not opposed by learned counsel for the respondent. Let this
9th
matter
April,
be
if I may, my lord.
listed for hearing on 9th of April.
April, my lord. I may be allowed to upgrade the matter if on that day, my lord, if it is.
On that day.
Good job, Les.
Item 20.
Item 20. Heard Mr. T. Kolita, learned counsel for the appellant. Also heard Mr. A. Hussain, learned counsel for respondent number 1 and 2. It is submitted at bar that this matter was referred to mediation, and during the course of mediation, an amicable settlement has been arrived at between the parties. I have also perused the report of the mediator, which is placed along with the, which is placed before this court. This appeal is accordingly disposed of in terms of agreement arrived at between the parties during mediation. The mediation settlement agreement dated 28/1/2026 shall form part of the decree. Prepared decree accordingly. This make appeal is accordingly disposed of.
Item 21.
Yes.
But in this case, lordship, we are challenging the liability imposed on the present appellant, lordship.
Liability.
Liability, because two vehicles are involved, lordship. As per evidence on record, the other vehicle is responsible. Eyewitness said so. Search is also given against other vehicles, but we are held liability to held liable to the extent of 50%. This is our main.
Holding that there was
Collision between two vehicles coming from opposite side. Head-on collision took place, lordship, at night, lordship. So we are also held liable to payment of 50% of the awarded amount. Charge sheet is filed against the other vehicle. The claimants had exhibited the same, and a claimant had also deposed that the accident took place due to rash and negligent driving of the other vehicle. And the other, we are insured of a I-10 car, and the other vehicle is truck. And the New India Insurance Company Limited had settled one case that arose out of same accident, taking full liability. So our plea is that our vehicle is not offending one, and so we are not liable to pay compensation.
no full liability in arising out in a other claim case arising out of same accident.
Same accident, the New India had settled.
New India is
New India is insurer of the truck.
okay. Who is representing? Mr. Bhatta. Okay.
See, this is different context, lordship. Since the driver of the vehicle was died, so question of charge sheet filed against him does not arise, lordship. Definitely the charge sheet will file who is alive, lordship. This is a case of head-on collision.
Okay. Let us see how court came to the conclusion that you were negligent.
May I read the judgment, Lordship?
Yes. Mr. Deka, you are for claimant.
I am for the claim.
How much you have received till now? 50%.
50% New India has given.
And
this
50
appellant has not been given anything.
Okay. Yes.
Lordship, judgment. Lordship, this is an application filed under section 166, laid with section 140 of the Motor Vehicles Act 1988 by the claimants praying for granting compensation on account of injury sustained by Sri Joyanta Kaur Roy, Joyanta Roy Kaur, in a motor vehicle accident. The case of the claimant in a nutshell is that on 1/2/2012 at about 11:15 p.m. while the claimant Joyanta Roy Kaur was traveling by Hyundai
Remaining counsel may not. How many matters are remaining? Putul. The remaining counsel may not wait because it will take time.
Item 22, I am saying a date, someone. Next week, mother.
Twenty-two.
22.
And the date due. 24th of March. 22, due to paucity of time, this matter could not be taken up for hearing. List this matter on 24th of March. Yes.
May I mention item number 25, my lord?
Twen-
Supplementary appeal 1.
20
Fix, my lord, after view bill.
25. Heard Mr. S.M. Borua, learned counsel for the appellant, as well as who is for the respondent. This matter could not be taken up for paucity of time. Hence, let this matter be listed on 28th of April. Yes, Mr. Vishwas.
Yes, I'm for the appellant. He wants, because today it is fixed for item number 24.
25, item number 20.
It will be not possible as your lordship has, a date may be fixed, your lordship.
Lordship, we have already filed RD hearing, IFR RD hearing, but the process could not be turned up, Lordship.
Okay. We heard Mr. A. Vishwas, learned counsel for the appellant. Also heard Mr. S. A. Bhakhtiar, learned counsel for the respondent. This matter could not be taken up for hearing due to paucity of time. Let this matter be listed on
26th, Lordship. 26th will be.
If it is
convenient.
possible,
We have
he wants
26th of March.
26th of March, Lordship.
Okay.
If it is possible.
Lordship,
Is it a hearing day?
Yes, it is a hearing day, your lordship. Thursday.
Okay, on 20.
my humble prayer is, can you do that, if it is possible, top of the list, it's the never ending process, could not be taken on time, Lordship.
On that day, you make a prayer
Lordship.
for upgradation because there may be more urgent cases than
Yes, sir.
yours
Lordship.
on that day.
Much blessed.
On 26th. Highly obliged.
Yes.
The case of the claimant in a nutshell is that on 1/2/2012 at about 11:15 p.m. while the claimant Joyanta Roy Kaur was traveling by the Hyundai i10 car bearing registration number AS23G0600 from Lidu Sahitya Sabha towards his residence situated at Tinsukia, and on his way when he reached at Kharjan Pole on the National Highway 38 under Digboi police station, the tanker bearing registration number such and such being driven by his driver in a very rash and negligent manner. That's the I-10 vehicle bearing registration number such and such from front side, as a result of which he sustained grievous injuries in his person. Immediately after the accident, the injured was taken to the Tinsukia Civil Hospital, Tinsukia, for his treatment, and thereafter he was taken to Sanjeevani Nursing Home, Dibrugarh, for his better treatment. As he was not fully recovered from the injuries sustained in the accident, he was admitted at AMCS Dibrugarh for his better treatment. After he was discharged from the said hospital, the injured was admitted at the popular nursing home Patna and then to Indian Spinal Injury Center, New Delhi for his treatment. It is also alleged in the claim petition that the accident took place due to rash and negligent driving of the driver of the offending vehicle bearing registration number such and such.
This is a case of injury case,
Injury case.
but Mr. Bhatto said that the driver died.
Yes, the driver. Here is two vehicle. One is I-10, one is oil tanker. I-10's driver is that.
And who is the injured?
Injury, he was inside, he's a passenger.
Oh, he's a passenger.
He's a passenger.
Okay.
He was inside the car. There were four passengers in the I-10 car.
Okay. So the claimant was one of the.
One of the passengers.
Oh, okay.
Negligent driving of the tanker. At the time of accident, the injured was working as a regional field manager of Sahara and his monthly salary was rupees 65,000. On receipt of notice from the tribunal, the OP1 National Insurance Company Limited contested the case by filing WS, denying the whole fact of accident as alleged and also denied receipt of any injury by the claimant. Involvement of the vehicle in question is denied and asked the claimant to produce copy of police report. Rash and negligent driving on the part of the driver is also denied. It has stated that two vehicles were involved in the accident and the accident occurred due to rash and negligent driving of the driver of the tanker and not due to the rash and negligent driving on the part of the driver of Hyundai I-10 car. Further denied that driver of the offending vehicle possessed a valid driving license. The insurance company denied the age, income, occupation of the injured as alleged in the claim petition. It is submitted by the insurance side that the claim of the claimant is high and excessive and the claimant is not entitled to receive the same from also further avert that if any term and condition is found to be violated, the insurance company shall not be made liable to indemnify the owner of the offending vehicle. On receipt of notice from the tribunal, the OP number 2, owner of the Hyundai I-10 car bearing registration number such and such contested the case by filing WS, denying the whole fact of accident as alleged and also denied receipt of any injury by the claimant. Rash and negligent driving on the part of the driver is also denied and also stated that the accident occurred due to fault of the driver of the offending oil tanker. Further stated that their vehicle at the time of accident was duly insured with National Insurance Company Limited by policy number such and such, validity up to such and such, and the driver had a valid and effective driving license, and he is liable to pay the compensation to the claimant. On receipt of notice from the tribunal, the OP number 3, the New India Insurance Company Limited contested a case by filing WS, denying the whole fact of accident as alleged, and also denied receipt of any injury by the claimant. Involvement of the vehicle in question is denied and asked the claimant to produce the copy of police report. Rash and negligent driving on the part of the driver is also denied. It has stated that two vehicles were involved with the accident and the accident occurred due to the rash and negligent driving of the driver of the Hyundai I-10 car and not due to the rash and negligent driving on the part of the driver of the oil tanker. Further denied that the driver of the offending vehicle possesses a valid driving license. The insurance company denied the age, income, occupation of the injured as alleged in the claim petition. It is submitted by the insurance side that the claim of the claimant is high and excessive and the claimant is not entitled to receive the same. Also further avert that if any term and policy condition is found to be violated, the insurance company shall not be made liable to indemnify the owner of the offending vehicle. None has appeared on behalf of the OP number 3, the driver of the offending I-10 vehicle, and the OP 5 and 6, the OP driver actually expired lordship in this accident lordship. OP number 3, the driver of the offending, driver of the I-20 vehicle actually expired lordship. OP number 5 and 6, owner and driver of the offending vehicle oil tanker in spite of notice, and the case proceeded ex parte against it. Upon pleadings, the following issues were framed by my learned predecessor in office: whether the claimant Joyanto Roy Kaur sustained injuries in the alleged road accident dated such and such involving vehicle bearing registration number such and such, and whether the accident took place due to rash and negligent driving of the offending tanker. Whether the claimant is entitled to receive any compensation, and if yes, to what extent and by whom among the opposite parties. The said compensation amount will be payable. During the course of hearing, the claimant cited adduced altogether 4 witnesses and exhibited a copy of accident information report, medical report, and prescriptions, medical expenditure bills, disability certificate, identity card, salary certificate, copy of FIR, MVI report, search sheet, seizure list, age proof certificate, and concession certificate by exhibits number 1 to 13. On the other hand, OP number 1 and 4 have adduced none. Decision and reasons thereof. I have carefully examined the evidences on record, and after hearing the argument advanced by the learned counsel for the claimant and the opposite party 1 and 4 as well, and do hereby pronounce judgment on the above issues as follows. Issue number 1, whether the claimant Jointo Roy Kaur sustained injuries in the alleged road accident dated such and such involving vehicle number such and whether the said accident took place due to rash and negligent driving of the offending tanker. The claimant side has filed the claim under section 166 of the MV Act. In the claim petition, the claimant implicated insurers, owners, and also the drivers of the offending vehicles bearing registration number such and such as parties to the case. The claimant number 2, Joyanto Roy Kaur, the injured during his evidence disclosed as on 1/2/2012 at about 11:15 p.m. while he was traveling by Hyundai i10 car bearing registration number such and such from Lidu Sahitya Sabha towards his residence situated at Tinsukia, and on the way when he reached at Kharjan Pole on the National Highway 38 under Digway Police Station, the tanker bearing registration number such and such being driven by his driver in a very rash and negligent manner. There's the Hyundai i10 vehicle bearing registration number such and such from the front side, as a result of which he sustained grievous injuries to his person. Immediately after the accident, the injured was taken to Tinsukia Civil Hospital, Tinsukia for his treatment, and thereafter he was taken to Sanjeevani Nursing Home, Dibrugarh for his better treatment. As he was not fully recovered from the injuries sustained in the accident, he was admitted to AMCH Dibrugarh for his better treatment. After he was discharged from the said hospital, the injured was admitted to the Popular Nursing Home, Patna, and then to Indian Spine and Injury Center, New Delhi for his treatment. He has also deposed that the accident took place due to rash and negligent driving of the driver of the offending vehicle bearing registration number AS23B 9981 tanker. The claimant has exhibited Exhibit 1, Accident Information Report, Exhibit 2, 1 to 197 medical reports and prescriptions, Exhibit 3, medical expenditure bills and identity card, Exhibit C, salary certificate, Exhibit 7, copy of FIR, Exhibit 8, copy of Azahar, Exhibit 9, 1 and 2, MVI report, Exhibit 10, search sheet, Exhibit 11, 1 to 2, seizure, 1 to 3, seizure list, Exhibit 12, the age proof certificate, and Exhibit 13, concession certificate. During cross-examination, she has deposed that she did not see the accident, but heard about the accident. At the time of accident, her husband was going by Hyundai i10 vehicle from Lidu. She has also deposed that due to accident, her husband sustained injuries in his backbone and his right leg was also fractured. She has confirmed in her cross-examination that the accident occurred due to fault of the oil tanker. Defense thou cross-examining the PWs, yet could not assail the evidence regarding rash and negligent driving of the driver of the offending vehicle, for whose fault the accident happened and the injury caused to the injured. The insurance side thou took the plea that the accident did not occur due to rash and negligent driving on the part of the driver of the offending vehicle, yet could not establish the said fact. Exhibit 1, copy of the accident information report shows this case being Digway PS case number 25 of 2012 under section 279, 338, 304A and 427 IPC was registered by Digway PS regarding the accident caused by the offending vehicle bearing registration numbers AS12, AS23G 0000600 I-10 car, and Joyanto Roy Kaur was shown as the ill-fated person who became the victim due to the accident. The evidence of claimants and the copy of the accident information report, FIR, seizure list, and search sheet proved the fact that accident was caused due to rash and negligent driving of the driver of the vehicle number AS23B 9981 tanker and AS23G 0600 I-10.
No, where is the evidence that I-10 was also involved. Who said that negligence was
There is-
in para 12, the court is coming to conclusion that the evidence of the claimants as well as accident information report proved the fact that accident was caused by drivers of truck as well as I-10.
Yes. But there is no evidence in this regard, Lordship. Now, the claimant Deepshikha Roy Kaur had filed a case as her husband, the victim, was at that point of time was bedridden. But later on, he also deposed that he is eyewitness to the accident. That he also said that the accident took place due to rash and negligent driving of the tanker, not of the I-10 car. This evidence in NCR, Lordship, may go through, Lordship. But after that, Lordship, it is I think,
The injured also was examined as
yes,
with-
yes, yes.
as PW or CW.
PW2. PW2, Lordship. CW2, joint or record. He had also deposed. Now, Lordship, this is the finding after paragraph 12. The DR was head-on collision between the vehicles and the search sheet was filed against the driver of the offending oil tanker. So, from the above discussions on evidences on record, it appears that the accident was caused due to rash and negligent driving on the part of drivers of both offending vehicles bearing registration number such and such, I-10 car and vehicle AS23B 9981 and a claimant joint or Roy for sustained injuries as a result of said accident. So, Lordship, this is the finding of the learned tribunal below. Lordship, my submission is that as because it is a only case of head-on collision, the learned tribunal came to the conclusion that the accident took place due to fault of both the vehicles. Now, Lordship will go to the issues. Issues were also framed in that rationalizing driving of the only tanker. There was no issue framed that the accident took place due to fault of both the vehicles. Issues also.
No, okay, issue was not framed.
Yes.
But whether evidence is there,
Evidence is there of the claimant.
even if evidence is
Yes.
not there.
Yes, claimant evidence is there, and the eyewitness who is a victim himself, his evidence also is there. Lordship.
His evidence was not discussed.
Not discussed, Lordship. Lordship, may we please to go to evidence, Lordship, in the trial court record.
PW2. There, give it there.
Lordship, I have got, Lordship, may.
You have it.
Yes.
Then you read it. I let Mr. Bhatto go through it. You read it, I will hear you.
I am reading PW2, that means of the claimant.
Who is the eyewitness?
That means injured plus eyewitness.
Ah.
I, Sri Joyanta Roy Kaur, son of late Prakash Roy. Prakash Parmis Roy Kaur, a village Lahori Poris, Makum, PS Makum, district Tinsukia, aged about 40 years by caste Hindu, by profession service in the district of Tinsukia, Assam, do solemnly affirm and declare as follows: that I am the claimant number 2, Joyanta Roy Kaur, of the aforesaid MSC case, and am aware of the facts and circumstances of the case, that on 1/2/2012, when I was traveling by a vehicle bearing registration number AS23G 0600 I-10 car coming from Lidu Sahitya Sabha to my residence Makum under Tinsukia district with my friends, suddenly tanker bearing registration number AS23B 9981 oil tanker, which was going from opposite side in a very rash and negligent manner, has knocked down the aforesaid I-10 car from front side on 38 NS way near Kharjan Pole under Digboi police station, causing severe injuries to my spinal cord injury and fracture of vertebra and other part of my body, and resultantly resultantly now I have become permanently disabled in life. That after the accident, I was admitted at Tinsukia Civil Hospital, Tinsukia, and then referred to Sanjeevani Nursing Home, Dibrugarh in the same day. After first aid in Tinsukia Civil Hospital, I was admitted in Sanjeevani Nursing Home, Dibrugarh on 2/2/12. Subsequently, on 11/2/2012, I was released from Sanjeevani Nursing Home and admitted on 12/2/2012 into the Assam Medical College and Hospital, Dibrugarh, again on account of financial hardship, and then shifted me to Popular Nursing Home, Patna on 23/2/2012 and admitted in the Indian Spinal Injury Center, New Delhi on 24/2/12 due to not getting satisfactory treatment in AMCH Dibrugarh. That still today, my treatment is going on as per doctor's advice in Indian Spinal Injury Center, New Delhi, and now I am permanently orthopedically handicapped with 50% disability. Exhibit 4.1 and 4.2 is disability certificate. That the accident took place due to rash and negligent driving of the driver of the vehicle number AS23B 9981 oil tanker, for which I have to suffer such physical disabilities and unbearable mental agony. That a police station case has been registered by Digboy PS GD&T number 35 dated 1/2/12, PS case number 25/12 under section 279 338 such and such, that due to this instant accident, I have to take care from any service without drawing salary and to suffer irreparable hardship to run our family, as well as to take proper treatment. Our family members consist of my son, wife, mother, brother, and myself, who are dependent only upon me. At present, I am totally disabled. I cannot lift my body. Exhibit 2.1 to 2/184, medical reports and prescriptions, and Exhibit 3 to 3/403, medical expenditures. I was drawn salary rupees 1,20,352. On in words also it is written my per month prior to accident. Exhibit 5 is identity card of Sahara India Financial Corporation Limited, and Exhibit C is my salary certificate. That my total expenditure for my treatment till date is almost rupees 25 lakhs, and now and so I claim for compensation of rupees 30 lakhs only from the honorable court. And now exhibits are mentioned. Exhibit 1, the accident information report. Exhibit 2.1 to 2.1.
Okay, what is the cross?
On 1/2/2012, I sustained injury due to accident that occurred at Kharjan Pool under Digboy PS. On that day, I was traveling in a vehicle bearing registration number AS23G0600 I-10 car. Suddenly, one oil tanker bearing registration number AS23B 9981 coming from opposite direction in a very rash and negligent manner knocked down the said I-10 car. As a result, I sustained severe injury on my spinal cord and fracture of vertebra and other parts of my person. Immediately after the accident, I was admitted in civil hospital, and thereafter I was admitted in the Sanjeevani Hospital, Dibrugarh, and I remained there for 22 days. Thereafter, I was admitted in the AMCH Dibrugarh and remained there almost 20 days. Thereafter, I was admitted at Patna Hospital, and thereafter I was treated at Delhi. I have submitted the medical documents of my treatment in above hospitals, which will be proved and exhibited by my wife Deepshikha Roy Kaur during the course of proceedings, with opportunity to the other parties for cross-examination. As I am unable to come to court, my wife Deepshikha Roy Kaur, I claimant number 1 will be present to prove the exhibit the documents on my behalf in subsequent days in this case. This is
so during cross-examination also,
he said that accident.
He has not pointed out anything showing negligence of driver of the I-10.
Yes.
So on what basis the tribunal came to the finding that?
Lordship, my.
Only basis is that there was head-on
Yes,
collision.
Lordship, that is, I think, Lordship, so that basis it was held.
It says so from the above discussions. Okay.
Yes, because it is a case of head-on collision, so liability was apportioned.
Any other submission?
Lordship, this is the main, out of 4 witnesses, he is only eyewitness. The claimant number 1, he did, she admitted that she did not see.
And
that
you
he
were
was-
submitting that
Yes,
the insurance company
yes, Lordship. The
has
other case-
already,
Yes, yes. This is in the evidence of Deepsika Roy Kaur. She has also stated regarding that it is in cross. That is in cross part that 304 in cross of Deepsika Roy Kaur. She had admitted that a case number 30412 filed by filed for Shankar Muzumdar by his wife. That means one Shankar Muzumdar was also expired in that accident. Shankar Muzumdar
Shankar Majumdar was the driver,
no, Lordship.
another passenger.
Another passenger of that I-10 car. And Shankar Muzumdar's wife, Dipti Muzumdar, had filed MSC case number 304/12.
Okay.
That is available in the cross-examination part of Deepsika Roy Kaur, the claimant.
But what
number 1.
happened to that?
That case, Lordship, New India Insurance Company has already settled, taking full responsibility.
Where is the, apart from your submission,
Yes, Lordship.
on what basis?
Lordship, it is in cross-examination part of,
She has stated there
yes, yes,
that it has been settled.
yes.
Okay.
That my learned panel also will admit this is fact, Lordship. It was settled by Lordship, New India taking full responsibility in that case. And Lordship, it is in this case, Lordship, eyewitness is in favor of the fact that accident took place due to fall of the truck, not fall of the tanker.
Eyewitness, only PW2
Yes,
is
yes,
the
yes,
eyewitness.
yes. He is the eyewitness.
Others are not
And
eyewitness.
others are not there. The other side was also, the New India also did not lead any evidence to prove that their tanker was not at fault. That our vehicle was also responsible. No evidence was led to that extent. And search sheet is Lordship Exhibit 10. It is in the TCR. Search sheet also specifically says that accident took place due to the fault of the driver of the tanker, not of them. And
Yes.
there are decisions of the Supreme Court of
What decision?
that in absence of evidence to the contrary, charge sheet can be taken into consideration. This is Kerala High Court judgment also. Person is aware about this and other judgment also there. Person may please be go through. In this case, eyewitness is examined. In cases where eyewitness is not examined, only on the basis of charge sheet, the court can presume that the charge sheeted vehicle is responsible for the accident. In this case, too, in addition to charge sheet, eyewitness is also examined to prove that
Yes.
this car is not offending.
Yes, Mr. Bhatto.
In this case, accident information report which was issued, that was against the national insurance company. Page number 79.
Page number?
Page number 17 in LCR. What's it?
Here photocopy is not there in the, okay.
The check mark is there. What's it?
Yes, what it says.
What is it? The L2 vehicle was involved in the accident. Accordingly, accident information report was issued
And
on the basis.
no,
of the-
there is no dispute to the fact that both the vehicles are involved.
Yes, let's see.
Both the vehicles are
Was
involved.
involved in the accident as per the evidence of the claimant. It was a head-on collision. What's it?
No.
It was
Let me put the query.
What's it as per the
In AIR only the Maruti car has been mentioned.
yes,
And truck,
that was not mentioned. What's it in the accident information report?
but that is not the final conclusion.
And what's it?
The truck has been involved in the accident is apparent from the
The
evidence.
truck was involved in the accident as per the Lordship MBA report. MBA report, both the front portion of the vehicle will damage Lordship.
No, Mr. Bhatto. On what basis the tribunal came to the conclusion that the driver of the Maruti was also negligent?
On the basis of the accident information report and on the basis
No,
of the-
accident information report only says that Maruti car was involved. There is no denial, nobody is denying that suppose a car is going in its own lane at a medium speed and truck comes on the wrong side and hit it.
there is no specific evidence that the car was in the wrong side, Lordship.
There is also no evidence because specific evidence is there that the truck was, it was due to the wrong of the truck. There is no evidence attributing any negligence to the driver of the Maruti car. Is there any evidence? Merely because there was a head-on collision. In every case of head-on collision, can there be a conclusion that both the vehicles are equally responsible? Driver, it cannot be said when there is evidence to the
If there is
contrary.
some positive evidence that the truck was come from the wrong side and it collided
No.
with the, then it is different thing, Lordship.
But the eyewitness has specifically stated, PW2 was the eyewitness, that the driver of the truck was at fault. And during his cross-examination, that evidence could not be demolished. So my query to you is, on what basis the tribunal came to the finding that the driver of the I-10 car is equally responsible so as to burden him with liability of 50?
As per the preliminary inquiry, Lordship, accident information report was issued against the National Insurance Company Limited, Lordship. This is the basis or which they can file the claim case, Lordship.
Anything else?
Lordship, I want to cite a judgment, Lordship, in case of head-on collision.
Yes. Paragraph?
Paragraph of last page, Lordship, will find.
Mr. Deka, how long you will take?
I'll take 10-15.
Huh?
10-15 minutes.
10-15?
Another, Lordship,
Then where is which paragraph, Mr. Bhattu?
Lordship,
The judgment which you have given earlier judgment.
Lordship,
Don't bombard with judgment without,
Lordship.
or I am giving you an offer. You come prepared. We'll continue this tomorrow or day after tomorrow.
Day after tomorrow.
Day after tomorrow is hearing day. We'll continue it as the first hearing item.
Lordship.
But tomorrow I will be.
Day after tomorrow. Day after tomorrow is hearing day. We'll continue this matter as the first hearing item. Then, and by that time, Mr. Bhatto may come fully prepared.
Basically, is a case of composite negligence.
No, but there has to be some evidence.
Yes.
My query is merely because, query to all of you, that merely because there was an head-on collision, can it be concluded that there was a composite negligence?
Contribute here to
Different thing.
So
So in case of a composite negligence case, claimant has the option to file the claim against one or both the vehicles.
No, but composite negligence means
Composite negligence means out of the action of two wrongdoers, a third person injured or died.
and contributory negligence.
Contributory negligence, if two drivers collide with the accident, one driver claim, then in that case,
The claim, okay,
in that
okay.
case, two judgment will clarify everything. I have two judgments.
That the
In that case,
claimant also contributed to the,
yes, in that case, court has to come to a specific finding. What is the contribution of each other?
but in case of composite
In case of
negligence,
composite negligence, court need not go to this aspect until and unless insurance company.
no. A question remains.
Yes.
In case of composite negligence also, merely because of the fact that there was a head-on collision,
Yes.
can court come to a conclusion that it is a case of composite negligence?
It is a composite, obviously composite, because there is victim is not involved in the accident.
No. I think this need to be, you clarify me on
Yes,
this
I'll
point.
clarify. These two judgments will clarify. I have two judgments. That
Now listen to my query.
in these two judgments.
That difference I have understood.
Yes.
That in case of contributory negligence,
Yes.
the claimant or the person who is on, for whom the claimant is seeking
Yes.
compensation,
Yes.
has also contributed to
Contributed to
and therefore percentage has to be assessed.
assess
And in case of composite negligence,
negligence.
the injured is, the aggrieved person is the third party
Yes.
who can claim compensation from any one of
Any
the,
one of them or
but-
both of them.
but when court can come to a finding that it is a case of composite negligence?
Composite.
Under what circumstances court can find?
Composite itself, it is a composite if the victim is not part of the accident, wrongdoers.
No, I am not in agreement with.
The judgment says, Lord. If suppose two
No.
drivers had
No,
a
listen
collision.
to me. You are slightly on the wrong side, slightly. Let me you clarify it to me on the next date. Merely because the claimant is a third party
Yes.
and two vehicles are involved, will it be in all cases a case of composite negligence? Or whether court has to first come to the finding
Yes.
that both the drivers were negligent.
Negligence.
Suppose Mr. Saikia there is no evidence on record that his vehicle is, driver of his vehicle is negligent, then still can it be a case of
In
composite
that
negligence?
particular case, insurance, national insurance, that is the I-10 car, insurance of the I-10 car has not adduced any evidence. They have relied on just the statement of the.
No,
CW2.
suppose they.
Only one statement that the.
Again, I have not gone into the issues. Suppose no contrary evidence comes on record against them. Nobody has stated anything accusing any finger to the driver of the I-10. They may choose not to adduce any evidence. The question of adducing evidence would have been required, would have come only if somebody have pointed fingers towards them. Neither the claimants nor the other side tankers nor the insurance company of the tanker had shifted, have stated anything pointing fingers towards them. Therefore, they have not adduced it.
I've got the point. Otherwise, also being a claimant, I have nothing to say. that
No.
I'm entitled for the
Yes, you will get compensation,
That
but
is,
you have to clarify
on
the,
basis of MBI report and lots of accident information, they could.
will continue,
judgment.
but you clarify me the difference between, not difference, what is composite negligence?
Yes, also if required, I can give you the judgments also, right now also. In two leading
No,
cases.
day after tomorrow we'll take some time and
Yes.
heard Mr. AJ Saikia. learned counsel for the appellant. Also heard Mr. K. Bhatto, as well as Mr. S. Deka, learned counsel for the respondent. Though the learned counsel for the appellant has completed his submissions, however, the counsel for respondents could not place their submissions due to paucity of time. Let this matter be listed again day after tomorrow, that is on 12th of March, as first hearing item and as a part heard matter.
Obliged, Lordship.
One more item is there.
No, my lord. I have posted, no, my lord, I but 26, I don't know 26 fine.
It will be shown as leftover.
Highly obliged.